ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Well, it gives me immense pleasure to introduce distinguished resource person, Professor Dr. Sripada Venkata Jogarao, who is presently anchoring the professional activities of Legal Excel Attorneys, a law firm of advocates, solicitors, and healthcare consultants based in Bangalore. Teaching career of Sir started more than 3 decades ago. Sir joined National Law School of India, University, Bangalore, as a founding faculty member in the year 1988. During his tenure at National Law School, he held various positions and rendered diverse nature of services, including teaching, research, and administration. Sir has taught many law subjects, and he has also participated in several research projects, national and international seminars and workshops. Sir has received British Council Fellowship and Max Planck Fellowship. Recently, Sir was invited to be a member of expert committee constituted by Government of Karnataka to review and recommend changes to new criminal laws passed by Government of India. After detailed deliberations, the committee submitted a detailed report, which in turn was endorsed by Government of Karnataka, and the same was shared with Government of India. I, on behalf of Karnataka Judicial Academy and all the participants present here, heartily welcome you, sir, with a big round of applause. I request, sir, to grace us with his insightful thoughts and enlighten us on the Bharatiya Nyaya Sanhita 2023 overview and comparison, additions, deletions, modifications, and reorganization of chapters and sections, and also different categories of crime, emphasis on crime against women and child, body, state, and property. Over to you, sir.
Thank you so much. Am I audible? Yes. Thank you. Visiting Karnataka Judicial Academy for the purpose of interacting with honorable judicial officers is always for me a matter of homecoming. Since the 90s, I was regularly visiting Karnataka Judicial Academy and had the opportunity of interacting with various officers. To begin with, the initiative to conduct a 3-day workshop, particularly focusing on capacity building relating to the new 3 criminal laws, I think is a very, very welcome step. Because all of us, not only judicial officers, even teachers, practitioners, every one of us, we need to know what the law states. To that effect, this particular program is very, very important. To this effect, for giving me the opportunity to interact, I firstly want to thank respected Honorable Justice Sunil Dutt Yadav, who spoke to me about the need for this kind of programs and asked me whether I'll be able to engage a couple of sessions. I readily agreed because even I want to learn, because learning is always ongoing. Every one of us. Therefore, I readily agreed, and for this, I am thankful to Justice Sunil Dutt Yadav. Similarly, I spoke to the Director of Karnataka Judicial Academy, Mr. Narhari Prabhakar Mathale, who spoke to me at least 3 or 4 times, inquiring about the kind of interactions. And luckily today I could come and spare the time. And our other friend, Mr. Satish, he was instrumental in looking into all my requirements. Even 10 minutes back, he was speaking to me, inquiring about where am I, how am I coming, etc., etc. I am really thankful to him. Out of all the members present here, the senior most Honorable Judicial Officer, Mr. Somshekhar, I am really happy to meet him. And recently only in Victoria Hospital, in one of the program, we met, and our association is quite long, and I always felt blessed to have his company. And one more person I just saw, my friend and advocate, Srinath and who is working as assistant prosecutor, and I know him, that's how, and I'm really happy. Let me just lay the canvas how I propose to cover, discuss, interact, and in the process learn. There are 2 sessions. Each session entails 2 topics. In total, 4 topics are there. We have roughly around 3 hours, 50 minutes time. I think we should be able to. I have prepared PPT so that all of us will be able to focus. Importantly, what I understand from Mr. Narhari is that the very precise purpose of this particular program, please remember, is very, very crucial to judicial officers and public prosecutors as well. Because in a judicial proceeding, the law is the lifeline. The law is the lifeline. Therefore, we need to know about the law. And in the process, we need to also look into whether a particular law, what has been stated, as you all know, from 1st July onwards, it comes into enforcement. Therefore, maybe in terms of any kind of merit, demerit also we need to know, so that we are in a better position to comprehend about the structure. Okay? I'll also share my experience when Karnataka government constituted the expert committee. Honorable Justice P.D. Desai was the chairperson, and we had very detailed discussions and deliberations, clause by clause, etc. That also I will share at the appropriate time. Okay? To begin with, I thought I will mention this is the first session. Personally, as a teacher, as a law practitioner, with conviction, I feel certain propositions which I learned more than 3 decades of my experience. I wanted to state those propositions to you to indicate what I think in terms of criminal laws. It is out of conviction I want to share with you. Those propositions which I have learned and also I have practiced in terms of either seminar presentations, articles, or even a couple of submissions before the judicial officers, etc. To begin with, the criminalization must entail legitimate justification. Criminalization, as you all aware, is the process of drafting criminal law. In other words, when you create a particular offense in terms of defining the offense and prescribing punishment, that is what we call criminalization. Criminalization is the forte of the legislature, be it parliament or the state assembly. The legislature has the constitutional prerogative. The prerogative is shared in terms of delegated legislation by others. But otherwise, the prominent role of lawmaking is always in the hands of the legislature. That is our constitutional scheme. Therefore, the process of criminalization, please remember, must have a legitimate justification. Criminalization or criminal law making cannot be a routine way of writing and using some words to indicate some purposes which are sometimes clear and many times they are unclear to the draftsmen themselves. I'm sorry for my observation, but that's a fact. Therefore, we need to really look into the first fundamental proposition, that legitimate justification. Whenever you coin a crime, whenever you define a crime, what needs to be followed? Secondly, the formulated criminal policy must cater and respond to the societal contextual need and necessity. A particular law which is 140 years old, etc., if it does not respond to the contextual need, the law must be changed. It is for the simple reason, as a matter of interpretation of statutes, Honorable Supreme Court and various high courts, they did say, though the law is stale, but the life must be given while interpreting the law so that the contextual need is responded. What I am saying is that is always there as a matter of interpretation for the honorable judges. But if there is a need for change for law, I think change must be effected. There is no doubt about it. Third, criminal justice shall be the ultimate objective of every criminal law. Please remember the word justice. The reason why I am using is earlier code, Indian Penal Code. But now it is a Bharatiya Nyaya Samhita, Nyaya, where even in the Lok Sabha records it is mentioned, the emphasis is on justice. Please understand, justice is the ultimate objective of any law and more particularly criminal law. But the means, please remember, the means is the criminalization and definition and punishment. That shall not be forgotten. Therefore, emphasis ought to be on what kind of criminal law we are making, what is the procedure, and what possible outcome it could be. Then comes, criminal prosecution shall not become a substitute for criminal conviction. My dear friends, this is something I very, very, very strongly feel. Of late, we have come across the Supreme Court judgments, at least a couple of them, where the Supreme Court wondered how come the case has been filed against these people. Very serious charges, non-bailable. The very institution of prosecution has been questioned. Therefore, I think it is necessary, criminal prosecution, an attempt, shall not become a substitute for criminal conviction. Which means, if you prosecute, that's enough. Whether he will get convicted or not, we are not bothered. I think in several respects, even a private complaint or an FIR that gets lodged, I think that requires to be taken note. Then comes, criminal law shall stand scrutiny of constitutional principles. This is the fundamental foundation of any legal system in any democratic country. Our guidance we draw from constitutional principles. Constitutional principles as interpreted by the apex court of this country. In fact, a couple of observations we made in terms of the deliberation. There were attempts to see whether Supreme Court observation or a decision can be followed or can be bypassed. It is the prerogative of the legislature. I don't have any objection. Please remember. But at the end of the day, the law which is passed by the House of the Parliament or Assembly must stand the scrutiny of constitutional law. Because constitutional law is the guiding light for all of us. Triology of criminal laws must aim at and ensure fair trial. Triology, Samhita, Nyaya Samhita, procedural law and evidence law. All three. Fair trial is something inherent and inbuilt constitution. That is something must be ensured. Then comes criminal laws governing investigation must ensure prevention of misuse. Very, very important. To this effect, caution must be employed while defining offences. In fact, thereafter I am going to tell you what are those principles which we need to take note whenever the legislature defines or makes criminal laws. Sentencing as a matter of policy must recognize judicial discretion. Judicious exercise of the same ensures proportionality of the same. These are the days where, not only now, for the last 2 or 3 decades, the legislature strongly felt and continues to feel minimum sentences, minimum mandatory sentences. I don't know whether any kind of social audit has been done in this country, how far they are effective in a country like ours. On one hand, truncating the scope of judicial discretion. On the other hand, legislative mandate. As a result, the proportionality of sentencing is losing its fundamental purpose. Judicial discretion ought to be the main forte. I think that trend of reducing the scope is something to be taken note. technology and scientific advancements must be given prominent role in investigation process, particularly the Nagarik Suraksha Samhita, very clearly mentioned about, I hope you are aware, in every district you need to have at least 3 mobile forensic science labs. A particular offense which carries a punishment of 7 years or above, the forensic examination is mandatory. I think these are the things which we need to really take note. And I must tell you, India stands second to none in terms of technology and scientific advancements. We need to properly utilize those advancements for the sake of ultimate objective of criminal justice. I think that's where it is necessary to be imbibed. Then finally, substantive criminal law must retain its identity and premise. Attempts to mainstream special laws into substantive criminal law must be restrained. Let me spend a couple of minutes in this regard. What do I mean with this proposition? Friends, in any country in the world, the entire criminal law is not in one code. Substantive criminal law is of one nature and identity, and depending upon the social conditions, depending upon the kind of threat the community faces, depending upon various developments. Please remember, criminality is not antiquated in the world. Criminality is more technological advanced. Therefore, the criminal law must respond to that advancement. Therefore, it is necessary substantive criminal law is at one level and various other laws which are also criminal laws, they are different. Both these segregated groups must be distinctly maintained. I'll just give an example. Narcotic Drugs and Psychotropic Substances Act. A serious problem which we are witnessing and continue to witness, particularly in some of the states in northern India, even today, as of today. The problem is so acute. As a result, 1985, the Parliament of India has taken a decision, which rightfully so, as a social need, there is a need for a separate, dedicated criminal legislation. No doubt about it. Like that, there are various, etc., etc., etc. I mean, the list is quite long in this country. But substantive criminal law continues to be Sanhita. But in the process, what is happening is, there were attempts, particularly in 2023 Sanhita, the mainstreaming of the special economic legislations or some of the select offenses in those economic legislations into Sanhita. Is there a need? If so, why? How do we justify? Mainstreaming of that particular, how do we really rationalize? I think that's a very important question to be posed. We were told, in terms of debates and various people who participated in drafting, they said mainstreaming is necessary because the volume of criminality is multiplying in this country. Therefore, we need to take note of it. I always felt the volumes should not decide mainstreaming. Volumes should be taken into consideration in terms of the procedural, the court proceedings, investigation, those things need to be taken note of, but not mainstream. But however, whatever said and done, it has been done, couple of offenses, which I am going to explain to you what exactly is the concern. Therefore, these are the propositions which I would like to share at the outset, so that you are clear as to what do I think and what is my experience in terms of my own learning. Then let's look into, these are the principles which I taught in criminal law for more than 3 decades to my students. First thing is, whenever we talk about the process of criminalization, criminal law making or criminal law drafting, maximum certainty. The words, the phrases that are employed to define a particular offense must contain maximum certainty. There should not be any slippery slope. I will give you examples in the new Sanhita, how those words have been used and how those words will have very serious practical implications while enforcing. And to what extent, in a way, they can be considered more for misuse rather than proper use. I think that's where it is necessary for us to look into how do we really take note of that. Second, the strict construction. Supreme Court of India, time and again, always emphasized, reiterated that the criminal law, the definition must be construed, must be interpreted strictly. If at all there is any kind of a larger elbow, the implications are different. The individual liberties are at stake. The people who enforce, they may take their own discretion, their own subjective viewpoint. The case at hand, the last couple of years, how Section 124A was subjected to enforcement in this country. I am not holding a brief if an individual commits an offense of 124A, he or she must be subjected to accountability. There is no doubt about it. But in the process, we needed to look into to what extent Honorable Supreme Court's Kedarnath interpretation we have enforced. I think that is one example to tell. Then comes broader purposive approach. Criminal law, please remember, must have a purpose. The purpose we must be very clear. Then comes presumption of innocence. I always asked my students in National Law School whether presumption of innocence, is it a fundamental right? If so, where is it provided? Many of my students used to say, no, it can be inferred under Article 21 of the Constitution of India, because as you know, Article 21, by virtue of the judicial interpretation, takes within itself more unenumerated rights than enumerated right of life and personal liberty. Therefore, that's one way of looking at it. But I always feel, whenever you talk about criminal jurisprudence, presumption of innocence is one of the very, very important principles. To this effect, let me go back to NDPS Act. The reason why I refer NDPS Act with a lot of passion is that there is one important section. For the first time in Indian criminal law, they have introduced, almost 40 years ago, almost. The section what I am referring is section 35. Whenever you are free, please go through that. But I am sure you are aware. It's called presumption of culpable mental state. You know what is a presumption of culpable mental state? The accused is presumed to have the state of mind which is mens rea. In whatever manner you interpret a particular offense, 21, 22, 23, whatever, the person is said to have presumed. That runs contrary to what I am saying, presumption of innocence. I always felt that section 35 constitutionality must be challenged. I think that's very, very important. There is every possibility Honorable Supreme Court may come to a conclusion justifying the kind of social menace we are facing. Because I always said the social context also must be taken. You can't harp on criminal law where the purpose is not served. No, social context also must be taken. But where do you draw the line? I think that's a very important challenge. Then comes fair labeling. Fair labeling, in my opinion, is very, very significant for the simple reason India, such a vast, diverse country, particularly the economic disparity, the literary disparity is so huge. Sometimes we wonder whether the person really understood what actually he has done, or are there any justifications why he or she has done. I think these things must be taken note while labeling a particular crime. Then comes proportionality. I always felt that the gravity of the offense, and the sentence what you impose must have a proportionality. There must be a scientific rationality in coming to a conclusion for this kind of offense, this needs to be done. On a perusal of Sanhita, if we take note, there is definitely a refined attempt to increase punishments for majority of the offenses. In fact, you will find, for example, death as a punishment. You can see, you will find a couple of. Similarly, life imprisonment or 10 years imprisonment, etc. My only point is that requires to be checked, tested in terms of proportionality. Then comes prior fault. That is, I always say, as you know, attanctus non facit rem nisi mensitria, criminal law, the fundamental maxim. Indian Penal Code never endorsed that. But the test what we used to follow, you look into the definition of a particular offense and see whether there are any words which indicate a particular state. For example, Indian Penal Code, even Sanhita also retained many words: dishonestly, fraudulently, voluntarily, etc., etc., etc. These are the words which we say the mens rea. What is the other important thing? Both mens rea and actus reus must concur together to constitute the crime. It cannot be mens rea 2 days ago, actus reus 1 week ago. No, it cannot be. It must concur together to constitute crime. This is what we learned as a matter of principle. This particular approach, no doubt, has been considered in this. Whenever there is, I think, consciously that they have done right, I have no hesitation in saying they have done right. No problem at all. But in certain types of serious offenses, this was given a go-by. I will tell you why. In India, there is one more, what you call, in terms of interpretation of criminal statutes. Not only now, I recall 1972 Law Commission of India report, 47th Law Commission of India report on social and economic offenses. Simple. The question is, what is strict liability? We say strict liability. In criminal law, do we have strict liability offenses? Of course we have. But what do we mean by strict liability? Strict liability means the offense doesn't require mens rea, it only requires actus reus. That's what is the general understanding of strict liability offense. I always felt that as a criminal law teacher, as a practitioner, one important book, every one of us we must read. I can give, send soft copy to our Narhari sir so that he can forward it to you. The book is The Common Law in India, 1960. You remember who is the first Attorney General of this country? Sorry? Correct? M.C. Settleward. M.C. Settleward was invited to London to present series of lectures. And he chose the topic, the common law in India. He covered various contract, admin, constitutional, criminal law, etc., and how the common law in India. In fact, the criminal law part, which he covers almost 40 to 50 pages, it's one of the scholarly, eloquent analysis about substantive criminal law of this country, where he mentions about these principles. Therefore, strict liability is nothing but where the offense does not indicate a word or a phrase which states the state of mind. If it is not there, strict liability. You remember 1964 Supreme Court judgment, Mayor Hans George, State of Maharashtra, Justice Rajagopal Iyengar and Justice Mudholkar. One of the very, Mayor Hans George is a German smuggler. That judgment is such an important learning for all of us. The first focused judgment in this country on strict liability. Particularly Justice Rajagopal Iyengar, the way he interprets RBA notification and accordingly there is mention about ignorance of law, those aspects also. But having said strict liability. Sorry? Hans, State of Maharashtra versus Hans, H-A-N-S, Meyer, M-E-Y-E-R, George, 1964, Supreme Court. This judgment is such an important thing for me because it really analyzes what constitutes strict liability offense. The issue involved is very, very simple. The issue is a particular notification was given, rather passed by RBI, and the person is already in his jacket some gold bars, etc., etc. Now the question is, did he commit offense? Then the notification does not use the word knowingly, intentionally, purposely, voluntarily, nothing. It only says in possession. That's all. Then the prosecutor argues, no, it says only in possession. Therefore, you don't require mens rea. Is he not in possession? Of course he is in possession. He himself said he is having the gold bars. Then Honorable Supreme Court said, yes, he is in possession. But is he in conscious possession? Conscious possession means, does he know what he is in possession? They said yes. The court said, if he is conscious about possession, offense is made out. Then many people thought, conscious, the word is indicative of mens rea. As a teacher of law, I need to clarify that. No, consciousness is not indicative of mens rea. Consciousness is only to avoid a possible situation. I am sitting, my neighbor puts gold bar in my jacket without my knowledge. I did not even know, but I am in possession. In such a case, offense is not made out. That's the essence of it. Therefore, Honorable Supreme Court in a very, very clear manner explained, even today, that's where I think prior fault is necessary. I am not saying that there is no room for strict liability, but adequate safeguards also need to be. You may ask what kind of safeguard? A strict liability offense must have, please remember, an opportunity for the alleged accused to prove that he is innocent. The kind of burden of proof what the prosecution carries will be on the defense so that the person is not helpless. The person must be given an opportunity to show that he is innocent. I think that's the essence of the, okay? Now, these principles, in my opinion, requires to be, and if you ask me whether these principles have been strictly followed in Sanhita, I think there are many instances where these principles have not been followed. And I'll give you examples also so that you. What are the changes at a glance? My dear friends, Indian Penal Code, as you know, 511 sections. Now, Sanhita 358, no change in 204 sections. Minor changes in 139 sections. You may ask what kind of minor changes, etc. British India has been changed. Or mental illness, insanity have changed. Like that, etc. Sometimes fine, some these, that, etc. 13 additional sections, 16 deletions. These are the changes at a glance. My viewpoint in this regard is opportunity to make it more socially relevant has been utilized. There is no doubt in that. But to what extent that utility, that's a question mark. Therefore, need for review, I think it is there. But to what extent you could really, I think that's a question mark. That we need to, for that we need to go into the details. For example, mainstreaming of special laws. I'll come from the bottom. Proceeds of terrorism. The provision vis-a-vis UAPA. Select words and used but not defined. For example, I think this is very important for both prosecutors and honorable judicial officers. The typology of punishment under new Sanhita, one welcome change has been introduced. I always felt that growing crime cannot be addressed by building more prisons. This is not what I am saying. This has been said for the last 8 to 10 decades. If ill health is a problem, building new hospitals doesn't take care. No. What needs to be done is to prevent. What needs to be done, that's where the sentencing jurisprudence. You know what is that new and welcome addition? Community service. But the problem is, there is no definition. My point is, see, all of us, as a teacher, as a judicial officer, as a prosecutor, you need to be given guidance. The guidance is very important. It cannot be a matter of individual. I think that is something new. To that effect, select word, for example, some of the words of Information Technology Act have been, but IPC doesn't, Sanhita doesn't say anything. Similarly, local authority, etc., general class act, everything. Then mental illness, as I told you, because in one respect, that is, I'm sure you are aware, earlier IPC section 84 insanity, general exception. Now, it has been reorganized in a different chapter that I will explain a bit later. But having said, they felt the word insanity is not appropriate. Maybe they are right. I have no problem at all. But what they said, mental illness is to be borrowed from the recent legislation of 2017. In this way, the kind of mainstreaming that is taking place. As a result, what happens is, the substantive criminal law, which must contain definitions as far as possible. Please remember. For example, even in Indian Penal Code, don't think that all the words of mens rea have been defined. No. For example, intentionally, has it been defined? No. But whereas fraudulently defined, dishonestly defined, voluntarily defined. Therefore, wherever there is a possibility of any kind of problem, etc., I think legislative choice, you can take a decision. No problem at all. But borrowing from other legislation is what how the reorganization has taken place. In total, 20 chapters, as of now, Sanhita. 358 sections. General explanations covered under section 3. In fact, earlier, general explanations, general exceptions, different chapters. General explanations, largely definitional information. 1, 2, 3, 4, 5, 6. General exception in terms of section 6, that's very important, indicating every offense, whenever it is to be interpreted, it must be interpreted in terms of exceptions, fundamental. Because exceptions, whether general exceptions or statutory exception, as you are aware, may lead to exoneration of criminal liability or mitigation of liability. Therefore, for example, earlier, culpable homicide not amounting to murder, 5 exceptions. Same thing has been retained under a different section. That's all. Number has been changed, not the content. Okay. Then comes group liability. This is where I personally felt the kind of treatment that was given in the Sanhita, somewhere down the line, I am unable to endorse that. Let me explain. As you are aware, section 34 to 38, particularly the charge 302 read with 34, or some other, etc., where we call common intention or group liability. Please understand, the criminality need not be individual in terms of perspective. It could be a group, more than 2, more than 3, etc., etc. But having said, the most important principle under section 34, common intention, Supreme Court made it very, very clear that under what circumstances the phrase common intention to be interpreted. There are so many judgments, very clear. what they have done is they have put it under section 3, 5, 6, 7, 8, 9. The same provision, 34 to 38, same thing they have. The reason for collapsing under section 3 is not clear. I always felt that section 34 group liability requires a specific mention and a specific section. Then comes general exceptions covered under sections 14 to 44. You remember 76 to 106? Earlier. 96 to 106, RPD. That has been collapsed. But the content, barring one or two sentences here, same. Then comes chapter 5, deals with offense against woman and child, 63 to 99, where earlier we used to have offense relating to marriage and some offenses with regard to the human body, etc. They have been collapsed, given a different chapter, woman and child. I think the treatment is necessary because they deserve, because many a time they are at the receiving end, either woman or children. Therefore, there is a need, and I fully endorse. Chapter 6 deals with offense against human body. 299 to 377, now it is 100 to 146. You may ask, how come the number of offenses came down? No, they have distributed in other chapters. That's all. That is where reorganization. Content, I will come to it. Notable additions. I think this is something we need to. We will spend some time also. 111 to 114, dealing with organized crime, petty organized crime, and a terrorist act. All the three are new offenses. All the three new offenses, they are not defined exclusively under Sanhita, but majority borrowed from respective legislation other than Sanhita. Okay, that we have to examine. Chapter 7 deals with offense against state, 147 to 148. But please remember, offense of section 124A, sedition, was repealed. Because that is what they have undertaken before Honorable Supreme Court also. But the new offense has been created under section 152. Act endangering sovereignty, unity and integrity of India. We need to really look into what actually this offense and whether the way it is defined, does it stand the scrutiny of principles. Chapter 17, dealing with offense against property, 303 to 334. Here also, earlier 378 to 462, collapsed and redistributed. One important offense has been created. It's called snatching. I mean, snatching, the way it is defined, is an aggravated form of theft. But the word snatching, because chain snatching has become a real menace in several cities, etc. Maybe in terms of social need, they have, I think it's fine. Common intention, this is what I told you about the which requires special treatment. With this, we conclude the first topic. Any questions, comments, clarifications? Normal, sorry, you're welcome, please.
The same penal clause, the same punishment is provided under POCSO Act, under section 6, section 4 and section 6. Then what is the necessity of the legislature? What is the object of the legislator?
Insofar as this section is concerned.
Yes.
You are absolutely right. In fact, when I said mainstreaming, I have taken only a couple of examples. I could not because of paucity of time. I did not understand the reason. No doubt they did say it is necessary to be included in Sanhita. No, I understand. But you have a dedicated legislation. POCSO, dedicated legislation is there. Then where is the need for? That is something I could not, I fully agree with you. I'll give one more example. I thought I'll give this example later, but in view of your question, I'm giving you now. Organized crime is there. Okay? And there is one explanation given at the end. You know what the explanation says? The superintendent of police of the concerned district will decide whether charge is to be under this section or under UAPA. If offense is the same, where is the need for incorporating? And after incorporating, where is the need for such a power to a police officer? Secondly, organized crime, no doubt it is a great threat to our social harmony, economics, no doubt in that. I mean, when there is a criminality, if there is a need for a kind of response, we must bat for it, no doubt in that. But you have included one more, petty organized crime. Therefore, the treatment of this nature, what is the need or what is the justification? We are not in a position to really get into that. Therefore, I endorse your observation. Okay? Any other questions? Observation? No problem. You want me to go back? Okay.
Maybe that I have not correctly ready. It appears 100 and, you have said 111 to 114 or so. I think 114, it was already there, hurt. I think it may stop at 113 and sir.
Okay, okay.
You may just check it.
Sure, sure.
Notable additions.
Maybe 111, 112, 113.
111 organized crime.
Petty organized crime.
112 petty organized crime.
Okay.
113 terrorist
Terrorist
act.
act.
114 hurt. Corresponding to
that
some
is-
390.
Instead of 14, it should be 13.
13, that's all, just.
That is the reason why I told you, your company is so important.
We also.
No, no. You are a beacon. Yes. That's Nagendra. Now, the point is, when once we say this, a kind of what you call the treatment that is given in Sanhita, now we need to get into specifics. For example, part 2, different categories of crime against women and child, body, state and property. For instance, chapter 5, offense against women and child of sexual offenses, 63 to 73. Criminal force assault against women, please remember, earlier 351, 352, 353, they are gender neutral. It could be man against woman or woman against man, etc. Now, that particular carved out and put it as a specific offense. Maybe it is necessary. Causing miscarriage, etc. earlier. Offense against child also carved out, and this is where some issues with regard to either POXO, etc., etc. Chapter 6, offense against the human body, 100 to 146. Offense against life, affecting life, 100 to 113. One thing I just want to tell you, the framework of culpable homicide amounting to murder, which is murder, culpable homicide not amounting to murder, negligent homicide, attempt to commit murder, the entire thing, almost the same scheme followed. There is no change. Maybe murder by, homicide or murder by life convict, there is a change. Not life imprisonment, death or life imprisonment, that kind of change. But otherwise, most of the things, the treatment that was given is more or less the same thing. I always felt, teaching criminal law for several years, for instance, you remember section 300 clause 3? Section 300 clause 3, there are two. Sufficient in the ordinary course of nature to cause death. Intention to cause that particular bodily injury. Same thing. The most landmark judgment, Supreme Court, even today it is valid. delivered in 1958. No, Nanavati is exception 1 to section 300. GSP, grave and sudden provocation. This is Virsa Singh. Virsa Singh, very important judgment even today. In fact, Virsa Singh further approved by Anda versus State of Rajasthan. Unni versus State of Kerala. These are the judgments. I mean, such great learning in terms of how the clause is being interpreted. But those judgments, even for Sanhita, they are relevant. You know why? Because the content of the law has not undergone the change. The only number and location, if I may use the word, they have changed. But otherwise, it. Then comes wrongful restraint, confinement, criminal force, etc., kidnapping, abduction, same thing. Then comes offense against state. Out of all the things, the act endangering sovereignty, unity and integrity of India, we needed to really look into 152. Then all other sections, more or less the same thing. Property, you remember theft, 303 to 307. I think 304 is snatching. Okay? Extortion, robbery, dacoity, misappropriation, criminal breach of trust, receiving stolen property, cheating, fraudulent mischief, and criminal trespass. Mischief, damage to public property, 324, if my memory is correct, that is given a special treatment. I mean, you know, a lot of vigilantic ideas where the public property becomes the most sought after victim or soft target for those unruly elements. Therefore, you need to protect that. How do we do that? I think that's it. I have selected certain offenses just to bring to your notice in what way they have been, in a way, different from the earlier code. For example, punishment for causing death or resulting in persistent vegetative state of. How many of you are aware or read the judgment called Aruna Shanbag? All of us, correct? Nurse, KMU Hospital, correct. Honorable Justice Kadju gave the judgment by the Supreme Court, and I can tell you, along with criminal law, I teach and continue to teach also health law and ethics, where one important area is with regard to the kind of treatment a victim receives on account of a medico-legal case. You know, in this case, the male nurse attempted to sexual assault her, etc., and something is put, and accordingly she became neurally compromised, etc. That fellow got bail in 1 month or so, and after 2 or 3 months punishment even that also served, and he is roaming free. But this lady was in the hospital for 34 years. Ultimately, she died. I think this is a very important offense. My dear friends, sexual assault per se itself a gruesome offense. But sexual assault leading to either death or, like Aruna Shanbag, not death, 34 years she was in the hospital. How many nurses have taken care, and I'm so happy that hospital also came forward, governments also came forward to provide. And I mean, Aruna Shanbag, you read the judgment, one of very few judgments, it's difficult to control your tears. When you read the judgment, tears. I personally acknowledge, and I think in the name of late Aruna Shanbag, this is a new welcome edition. It is necessary. Sexual intercourse by employing deceitful means, it has become a kind of thing. As a result, there is a need for a particular offense where the punishment is proportional. Disclosure of identity of victim of certain offenses. No doubt, Indian Penal Code also carried one provision, CRPC also has provision, etc. But it is more observed in breach rather than in confirmed. I mean, first thing is, first day they don't release photo, name they release. Second day they release photo also. and no action, nothing. And many people do not even. I think this is something very, very important. It is not only in this, please remember, even to cover the court proceedings. Proceeding without permission. That is also, in my opinion, that is necessary because, I mean, generally what happens is a woman who is subjected to sexual assault in this society has to face several assaults as she goes through the process of investigation, etc., etc., etc. Even sometimes courtroom proceedings, the kind of questioning, the kind of thing, etc. As a consequence, the ostracization, the kind of shaming, the kind of punishment which indirectly she faces, I think, how can you prevent that when identity is kept confidential? I think that is the reason why, yeah, I mean, I don't think we should really go on reporting who is this, that, etc. There are many other things which can be reported. Cruelty, I think 498A, the word was here they have defined, and I think more or less a purpose is served. For example, harassment of the woman where such harassment is a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, etc., etc. I think a kind of judicial guidance. I always felt it is necessary so that as judicial officers, as prosecutors, you are in a better position to ensure justice is rendered. This is something I want to mention. My dear friends, as I told you, I teach health law also, healthcare law. This is one section which really took our attention. What is stated in media is different. What is stated in Lok Sabha is different. What the bill says different. And what ultimately Act said is entirely different. In the meanwhile, there were advertisements in the newspapers. I am sure every one of us you must have seen. Thanking Prime Minister, thanking Home Minister, that negligent homicide by doctors is decriminalized and we are fighting for the last 30 years, these, that. When I saw the advertisement, when I saw the law, I am unable to understand which one is correct. The law says something. Therefore, I must tell you, in between, the way the law was drafted, I had serious reservations. In between, what happened? Our truckers strike. You remember how many kilometers the trucks, etc. As a result, part 2 is not notified even today. Even today, it's not notified. Let me explain. My dear friends, section 304A deals with negligent homicide. Earlier, rash or negligent, which is not culpable homicide. That's all. Death, cognizable, bailable. Please remember. Or fine or both. Okay? Imprisonment up to 2 years. That's it. Naturally, whenever we talk about negligent homicide, we definitely consider hit and run cases. I think that's negligent or rash, that word or phrase put together indicates that. There is no doubt in that. But they have introduced something very interesting. That is number 2. What is that they have said? Whoever causes death of any person by rash or negligent driving of vehicle not amounting to culpable homicide and escapes without reporting to a police officer or a magistrate soon after the incident shall be punished with imprisonment of either description for a term which may extend to 10 years. Two points. Number one, what is that? This 10 years is not for killing, not reporting. For killing, how many years? No, I am asking you. No, what is that? For killing, you say 2 years, but not reporting 10 years. Trucks, they have stopped for several kilometers. There is a reason. You know generally what happens. Generally, I am not holding brief for a person who drives negligently. No. If you are negligent, you must be punished. But there are many factors which contribute to an accident. It could be the road, it could be not having light, it could be rain, it could be X, Y, Z, or contribute to negligence of the pedestrian or a bike rider. possible. As a consequence, the moment if death takes place, he runs away. You know why? The people surrounded, they may lynch. Instead of, please remember, he committing an offense, he becomes victim of a new offense which Sanhita creates. That is mob lynching. Yes. If so, how do we rationalize? Even today, I did not understand. But one thing, they said this part 2 we will hold, and they are having negotiation, etc. I am sure punishment will be reduced. There is no doubt in that. In fact, this is what I felt. Nobody asked me, but unsolicited advice we can't give. Therefore, Jogara chup, they may say. I am asking, if a person surrenders to the police, his conduct must be incentivized. That is what I am saying. So that people are encouraged to seek shelter. Please remember, this, they made it an offense. You know why? Even the draft committee, they are aware possible potential mob lynching. Protect his life, better he is with an authority. They are right. But not doing 10 years imprisonment. Yeah, very honestly, definitely there must be reduced. But I think incentivizing is more important. So that the individual thinks, after all, I am sure he also will have family, children. Who wants to have the kind of life where, no. Therefore, incentivizing is one. How do we do that? Mitigating sentence could be one. That's where your role, prosecutor's role, is very important in sentencing. That's what therefore, what I am saying is, you need to really look into in this way. But I have one more concern. You know what is that concern? Explanation you read. For the purpose of this subsection, registered medical practitioner means a medical practitioner who possesses, etc., etc. Suppose if it is a medical doctor, then the punishment is 2 years. Okay. Suppose if I am a Bharat Bench transport driver, I come under the first part. Okay. Suppose I am Dr. S.V. Jogarao, surgeon, I come under second part. To that effect, they have shown a kind of thing which is nothing but retaining earlier legal position up to 2 years. But the part 2 is there. This is something very, very interesting. Say for instance, I am a surgeon, I conduct surgery, and during the course of surgery the patient dies. Can I be prosecuted for part 2? You think I should not be. But read, for example, whoever causes death of any person by rash or negligent driving of vehicle not amounting to culpable homicide. That is something we have intimated. Earlier, driving vehicle is not there. As a result, even in the case of rash or negligent homicide in the context of a medical, if the doctor doesn't surrender, doctor will be, I think that is again irrational. I think that clarification has come. But the second part is kept in abeyance. Maybe after discussions, I think they may. Snatching. You remember I mentioned snatching is in the form of an aggravated form of theft. Theft is snatching if in order to commit the theft, the offender suddenly or quickly or forcibly seizes or secures or grabs or takes away from any person or from his possession any movable property. Whoever commits snatching, etc., imprisonment for return 3 years, etc. My dear friends, one thing I want to, this is my personal, I do not know what you think. Even if you take a different opinion, I have no problem. I encourage dissent, no problem at all. law in written form is nothing but the alphabets, letters, words, phrases. But the word what you use in law, you must be very careful. That's what I personally think. I'll give an example. Grabs. You just look into, in any kind of context, the word grab. But Sanhita uses in two different contexts. One is land grabbing, second one is grabbing a chain. I think the word one has to be very, very careful, because if the word is amenable to multiple interpretations, then it should not be. The word must have strict construction, indicating maximum certainty, just definitiveness, very important. I think to that effect, couple of circumstances I noticed. Very honestly, if they retain, I mean they have retained of course, but we have to see how the judiciary interprets this particular. With this, we complete the second one. Please. 303. No, life convict, no? 303. Correct, correct. Mithu versus state is unconstitutional. Yes. No. Kindly read one. Swamiji, mic. Swami, mic. Please understand, he is seeking a clarification vis-a-vis earlier Indian Penal Code 303, Swami Shekhar Sahib Code, and current 104. I want every one of you to listen. It's very important question. Go ahead.
104. Whoever being under sentence of imprisonment for life commits murder shall be punished with death or with imprisonment for life, which shall mean the remainder of that person's natural life.
Correct.
Of course, 303.
No, one nimisham. Please come to 303.
303 old.
Old. You have criminal manual, Nagendra?
303 old.
3. ನೀ ನನಗಲ್ಲ ಸ್ವಾಮಿ, ಹಲೋ ಸಾಹೇಬ್ರಿಗೆ ಕೊಡಬೇಕು. 303, in this book, they gave knowledge, and you are always a super senior citizen. I am also a senior citizen.
Just tenure to me by 4 years, that's all.
Sir, may I tell you one thing?
Yes.
Age is a number.
Yes.
You know that. 303, please read, sir.
There is some change. There is some change.
No. ತಾವು ಓದಬೇಕು.
Okay, 303. Whoever being under sentence of imprisonment for life
Correct.
commits murder shall be punishable with death.
That's it. But whereas 104 added or life imprisonment.
Yes.
You know why? In Mithu versus State, Honorable Supreme Court said only life, only death for life convict is unconstitutional.
Okay. Clarity.
That's
Thank you, sir. Thank you.
It's a very important question, sir.
Thank you.
The reason is, in certain respect.
Don't mind keeping this book with me for some more.
No, you have to ask madam. No problem, no, he can keep, no, because I am sure I'll be, no, keep it. I'll be asking you several questions.
Hello.
The reason why I am,
Indian Penal Code has never been my cup of tea.
but you raised a very important question.
Somehow I got 69 in criminal law in Lata. In my Favorite subjects, I got 35, 40. Favorite subjects, UPSC and other things.
No problem. But your knowledge is something sharing with all of us very important. My only point is, this is an important question, you know why. In terms of social need, a life convict committing an offense of murder is not uncommon in this country. I'll give an example. The person commits an offense, languishes for 1 or 2 years, gets bail, immediately he commits a couple of things. Therefore, that is not a kind of a very rare thing in this country. No. Therefore, murder by a life convict must be a punishable offense. Having said, Supreme Court is also right, constitutionality. Therefore, while redrafting, they did consider that. They thought, why not life imprisonment? Therefore, pleasure. Friends, I think these are the ways in which the specific offenses, etc., they have covered. As I mentioned, the criminal policy in terms of what is the social need, how do we really draft a particular criminal offense, is what to be tested. For instance, you remember 309 earlier, attempt to commit suicide? Okay. 309. 306 abetment. 309 attempt to commit suicide. What was the Supreme Court judgment? Correct. But legislatively they never repealed. Even 303, the legislative, they never repealed. Now there is no need. That's a different matter. But in Sanhita, attempt to commit suicide has been retained. I am just giving one important, if my memory is correct, maybe 126 or something like that. Must be. The reason why I am sharing is this. As you all aware, attempt to commit suicide may have multitude of social reasons. Multitude. But one important reason could be the person may protesting a particular execution of public authority or functionary or some other thing. The person says, I'll commit suicide if you continue to do that. They carved out that particular thing and they have introduced. For example, whenever any competitive examinations, results, these, that, etc. For example, the kind of problem we are facing this time, NEET, you know the kind, I mean lives of the people, young people, they may have so many frustrations, so many hopes, I mean parents, these, that, etc. I mean, it is, we have reached a stage where it is very lucky that if the student doesn't take that option, we are lucky because a lot of pressure, stress. But that cannot be treated like what you call preventing a public functionary to exercise his authority. No, that is different. Therefore, in my opinion, the purpose for which this new offense has been is clear from the offense. But there are so many other reasons because of which an individual may commit attempt to commit suicide or may attempt to commit suicide. I think that is something we need to take note. Very, very important. You may ask a question vis-a-vis the other reasons like maybe love affair or some other or examination or some other health, these, that, etc. If an individual attempts to commit suicide. On one hand, 309 was held unconstitutional, but later Mental Health Care Act has incorporated a very important provision where they did not mention about criminal prosecution, but they said the individual may require psychiatric counseling and the individual may require psychiatric care. My dear friends, I mean, we worked when I was in National Law School with then Dr. S.M. Channabaswanna, the director of NIMHANS. I'm talking about 30 years ago. we used to have lot of National Law School, NIMHANS, workshops, seminars, discussions on suicide. Suicide prevention, how do we do it? In fact, as a result, I personally got to know so much of insight why people do commit suicide. I mean, I only read paper or some mishap, neighbor or something, then you get to know. But otherwise, there is no other possibility. When once we got to know these are the things, etc., we understood. Prosecuting a person, you know what happens? You are encouraging that person to make a successful attempt once again. I think that's not correct. Life is valuable. My dear friends, I will tell you, I cannot step into the shoes of a person who is feeling so insecure because I am different. He is different. She is different. Life is common. You can't have a kind of, most coerced and most difficult situation where the person looks forward to die rather than live. Law must create an atmosphere so that the person opts to live. I think that's where this part I understand, whatever I mentioned. The other part, I think that requires to be very, very clearly pronounced. In my opinion, maybe in terms of discussion, interaction, we need to emphasize on that. Now, any other questions, etc.? Normally, law school, I used to follow one thing. Don't think that I don't follow now. Even now I follow. If you don't ask questions, I'll ask questions. Please, you are so intelligent. She did not give me even half a minute time. Immediately she said, please go ahead. Mike, Swami. Sir, I have a very much honor. Please. In fact, to tell you very honestly, the intent, in terms of intent, what I gather from various colleagues and other like-minded people, is that to prevent a gross injury to him or her, why not put a duty so that the person can seek shelter with an authority so that his life can be saved. That is what appears to be intent. And very honestly, the recent vigilantic mob precedents in this country, not only lynching and X, Y, Z, etc., so many. Therefore, we are worried what happens to that driver. But I agree that in what way we can implement.
Basically, my concern is, are we that sensibly accountable? ಈಗ ಡ್ರೈವರು ಓಡೋದು ಅವನಿಗೆ ಇಂಪಾರ್ಟೆಂಟು.
ಕರೆಕ್ಟ್.
ನಾನು ಹೋಗಿ ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಮಾಡಬೇಕು, ನನಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಸಿಗ್ತದೆ ಅಂತ ಹೆಂಗೆ ಅವರಿಗೆ ಗ್ಯಾರಂಟಿ ಕೊಡಿಸ್ಬೇಕು?
ಯು ಆರ್ ರೈಟ್. I mean, that is the reason why I always said, when you make a law, first of all, you think whether law can be meaningfully implementable.
Yes.
Without making any kind of such kind of homework. See, for example, I want my granddaughter to be in swimming. I'll take her to swimming pool, etc. But she is afraid of water. What is the use? What is the use? What I am saying is the infrastructure, the logistics, the kind of thing, etc., etc. And law is going to come, not this part, I am saying other thing, 1st July onwards. In fact, many people are wondering whether all the things, particularly Suraksha, what all things we said about, etc., whether there is everything in place, whether law will be able to be enforced in that manner. That's right. In spirit of the law. No. Therefore, I agree with you. That is what I say. Not that I want to paint government in black or something. But I think that is something must be taken into consideration.
Yes.
Without which, law remains a letter on the paper, but not in the life or in practice.
Sir, one more thing, sir.
Please,
We are so honored. In 1998, I remember we were assistant public prosecutors. Then you had very good, this one, sir, victim definition, victimology.
Okay.
But
Oh, I see.
unfortunately, in 98, that concept was brought. But it was amended in the year 2012.
12.
2WA ಅಂತ ಅದುವರೆಗೆ ನಾವು ಏನು ಮಾಡಿದ್ವಿ ವಿಕ್ಟಿಮ್ ಬಗ್ಗೆ ಕನ್ಸರ್ನ್ ಇಟ್ಟೇ ಇರಲಿಲ್ಲ.
Correct.
We remember, sir.
I am thankful to you and God. 98 means what? 2 plus 20 for 26 years ago.
Yes, we are all from that person.
Really, thankful to you.
Thank you,
Really,
sir. Thank you, sir.
I mean, see, I always feel and continues to make it a conscious choice. Whatever we do, it should be purposeful. If it doesn't serve the purpose, the best thing is don't do it.
Exactly, sir. Exactly.
If it
Thank you.
doesn't serve the purpose, don't do it. Thank
Yes,
you so much.
thank you.
Very sorry.
Sir, in
Yes, please.
continuation of that 304 previous IPC,
Yeah.
I feel that if the driver commits offense under 304A, he definitely informs his owner through phone or electronic or whatever means, or any other person knowing to him. A provision is made, the person who knows third person, if he reports the same to the police, that can be an exemption for 10 years punishment. It can be implemented in a better way because he definitely informs some other person, here his wife or his owner or transport company or such. In other words, insurance company. That owner, if he informs the insurance company, it can be considered as a zero FIR and it can be made out to the particular, and it can serve as a exemption for that particular driver,
Okay.
though he ran away from the spot
Right.
without making such things.
Yeah.
And the concerned police can also take care of the victim and such other things
Right.
also.
Whatever is security. Or
Yes.
I'm very
He can
happy
be given a
that,
social security.
Yeah, I'm very happy that you are, see, what I understand from your observation is, you, while endorsing the intent of this part, you are only looking into how effectively it can be implemented. That is something very important. See, all of us, we need to put our collective efforts to see, for example, owner or wife or father or somebody, he will inform. If that person informs the police, whether definitely it can be done. That's what I'm, see, at the end of the day, what state of mind the driver will be on that at that point. For him, he wants to run away because he wants to save his life. Therefore, and another thing, we are very good in certain principles. We means law, all fraternity, everybody. We say ignorance of law is not excused. But what we have is tremendous ignorance. I always said, people say common sense. But common sense is very uncommon. Common sense is very uncommon. As a result, it's very ignorance. I mean, how the truckers or people must be told. I think education, dissemination, these things are necessary. The way we are doing it here, I think it is necessary for general public as well. Particularly when the consequences are so stringent in nature. I think what happens to his family, I was mentioning about his children, etc. I think those things must be kept. And I was told, I mean, before coming to this program, I did inquire from my own contacts who are reliable. I asked, is there any development with regard to Part 2 notification, etc.? They said discussions are on. I mean, last 2 months because of elections, nothing moved. But now discussions are, I think, in all probability, within 3 months we may come with the suggestion. That's what. And I'm hoping collective endeavor, if it leads to purposive, broad-based approach, I think that's the, at the end of the day, in a democratic country, that's what we look forward to. Thank you. Any other? Can you not sit for some time? All along you were standing like that. For me, my standing is I can't sit. Either in the class or in the court, I cannot. You can sit for some time. And, yes, any question? Yeah, what about you? Can I ask one question? And I leave it to you, whoever wants to answer. Multiple also, we will give the opportunity. Did you, in your experience, come across a situation or a context where, as an honorable judge, you are bound by the law, that is minimum mandatory sentence, a particular offense, whichever offense, minimum mandatory sentence. As a judge, by looking into the evidence adduced, the parties, blah, 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 did you face a situation where the accused doesn't deserve minimum mandatory sentence? If so, what are your options? Which option? 1958. But there must be 21 years. Probation of Offenders Act only you are referring, right? No, it's not. No, all offenses are not. That's one way. Not applicable. Particularly economic offenses, no. Ruled out completely. Any other, I mean, did you face that situation? I am asking. No. Why you have not, I mean, okay. Okay. Correct. Correct. Okay. A situation where you felt whether misrepresentation as to whatever fact, did it continue throughout the period? Okay, 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 okay. Okay. Okay, that also you made clear. That consent is no consent. Correct. Correct. Therefore, it is no consent. If there is no consent, it amounts to rape. Yes. What is your concern in giving 10 years to him? No, but okay, that's what. I mean, according to you, 10 years more. Yeah. The reason why I am asking is minimum mandatory sentences where the judicial discretion is literally negated. Restricted Allah, it's not there. Minimum sentences, it is restricted. But minimum mandatory sentence, on the fact and circumstance. You are right. Okay. Correct. Minimum sentence, I agree with you because, yes, yes. Minimum sentence, as you said, the law itself enables you to provide less than minimum, provided you record reasons for this. Yes, You are right. That is something very important. I mean, very honestly, at the end of the day, what is an assertive reason is a kind of individual to individual. And in my opinion, that cannot be taken away. I mean, see, whatever said and done, judicial mind, why do we say judicial mind? We say because individually judicial officers must be enabled to apply. So that let them. I mean, there may be a possibility 2 out of 10 may give wrong reason. That's okay. It is in the process you learn. All of it. I mean, for example, when I first started teaching criminal law, I'm sure at one level I would have committed mistakes, these, that, etc. But I'm the next time when the kind of dilemma you shared. These are all part and parts of learning. The reason why I'm saying is, somewhere down the line, as a teacher and as a practitioner, I strongly believe in consultative interactions. For example, whenever we talk about criminal law, is there any way honorable judges were consulted? Why honorable judges always they come just before notification training purpose? Why during law making? I mean, you are a very important stakeholder. Your opinion, your experience, your wisdom. Why we are not able to? I agree that there are hundreds of judges, Jogara. How do we? No, it can be. You mention maybe Karnataka, 2 or 3 districts, randomly select, constitute a committee, they will work. Maybe 1 month, they give. I think that way it can. I mean, I don't think it is such kind of thing that it is impossible. No, you are a very important stakeholder. We need to know your views while making law. But you are always remembered when law is made. That the only book, then you have to implement, and you become. That is something I always, particularly with regard to sentencing, interpretation, the definition of offences, etc. Very, very. When I say honorable judicial officers, please remember, I mean at every level. At every level. I am sure honorable Supreme Court and honorable High Court judges, they have their own experience. I think that is always felt. I am not talking about only X government, Y government. You are right. You are to some extent, but correct. But what I am saying is, I am just giving a kind of example. You might not have delivered a judgment on a particular topic, but as in the light of your experience, you may have an opinion to share. That is something we are missing. Judiciary, please remember, judiciary has a very important role in terms of law making. Many people say, no, they are all passive spectators. They are like umpires. No words about their role and responsibility. Only when the law is made, you go to them and say, this is what is to be done. That is what is the problem. My own understanding about what judiciary in terms of law making, I agree that interpretation and enforcement in terms of interpretation is judicial responsibility. But as citizens of this country, I think you have a larger role in terms of shaping, a lot of things with regard to policy formulation. I think that is something, maybe in future at least some kind of, please. Correct.
Something in this regard.
Correct.
You have also given the report.
Correct.
It's not proper for me to ask you,
please,
whether everything suggested by you or pointed out by you in the report is finally reflected. I do not know. Well, I don't ask that also. I will tell you my own experience about it. After my retirement, I retired about 8 years, exactly 8 years back. Maybe some 2 or 3 years back, I was asked to give a note suggesting some amendments to the Criminal Procedure Code in the light of my experience as a trial judge.
Okay.
I personally find even to this day, even under this Bharatiya Nagarika Surashya Samhita, there are many situations for which the code does not provide. Unfortunately, 482 CRPC
High Court.
is only for the High Court, not even for the Supreme
Correct.
Court.
Question.
There are many situations which magistrates and sessions judges are facing. Somehow they are managing. For example, this B report, C report, CRPC doesn't provide for it.
Correct.
We have our own procedures. And as a judge who had been a trial judge for 31 years, I found practically the summary trial, summons trial, warrant trial, in effect, they have remained the same. Whether you are not able to regulate and control the proceedings is different. I admit my failure. But by and large, nobody has been able to do it. Keeping all these things in view, lack of a provision similar to 151 CPC, enabling, if the concept under 151 is, by the very constitution of the court, there is that power inheres.
Correct.
It is not that 151 confers, it only recognizes the power
Correct.
which you already have.
Correct. Correct.
If a civil court can have such a power which is recognized, I really see no reason as to why a civil case where the states are hide civil law, I think at least this magistrate should be able to deal with that.
Sure.
I prepared some 12 or 13 pages note. I asked the concerned person, sir, yavaga, as early as possible, at least tomorrow. All right, I gave it. And I don't think, except one thing with regard to discharge of an accused even in a summons trial, I don't say that it is on account of my suggestion, certainly not. Somebody else would have done it. Nothing which we suggested, which I suggested, and subsequently also somebody told me and we sat together, I don't think that anything has, I have no problem with that. Certainly I have no problem with that. But what I find is, even if we give such suggestions, are they something with regard to this Arbitration and Conciliation Act also? A team came from Parliament. They went to Legal Service Society, Mediation Center, Arbitration Center. Since in the academy there was enough space for them to sit and talk. I and another good friend of mine who is also an arbitrator, we gave some suggestions to that. They were not patient enough. I had some difficulty because I can't understand Hindi or speak in Hindi. They started telling in Hindi, I said English. The then director of the academy said, "Nan ಹೇಳ್ತೀನಿ Hindi, don't worry." So he said something. When everything happened, you please put it in writing and send it. So I and my good friend sat and everything we wrote. Nothing has happened. That's all. Nothing more. I have absolutely no grievance. I am too small a person to suggest any amendment or anything. But when you said why not this judge's opinion taken, maybe at the level of the Supreme Court or the High Court, when some observation is made in some judgments, we have seen that there is a legislative reflection of many of the observations made by the Supreme Court, not only in civil law, criminal law, but very rarely the suggestion or opinion of a trial judge serving or retired is taken. That's all, nothing more.
Yeah. No, the beauty in your submission is that you made it very clear that you are not going to ask me a question. But at the end of your observation, you made it very clear what is the question. That is where experience matters. Let me share with you, sir. I always, in terms of as a lawyer or as a teacher, I say this is what is the advice I give. Maybe opinion, X, Y. We are here only to advise. What is that the person to whom you gave what he or she does is their fault. Another thing I just want to tell you, many times the consultative interactions, they are for the sake of consultations. You have spent time in preparing a note, discussions, everything because you are conscious about it. But for whom you do it, they may not attach that much importance. Very frankly, the kind of things, I have reached a stage where if somebody asks, I give it. That's it, leave it like that. Whether they act upon it, whether it is for them to leave it. But I still continue to repose faith in deliberation, consultation. In my opinion, it needs to be done. So that, the way the people can involve and the kind of, I agree in terms of numbers, volumes, the kind of practicality, etc. But I think you need to find a way in which it requires to be done. That's what is the. Yes. Any other questions? Yes, please.
Care whether you are taking or not. He shines for everyone.
Correct.
What I personally feel.
Hmm.
Shouldn't demotivate just because nobody is listening to us.
Sure, definitely.
Whatever we feel, we should honestly we should do.
Sure, definitely. In fact, I always felt that all of us, professionally we have one personality, but otherwise the personality of a citizen of this country continues to be. Every one of us, irrespective of whether age, retired, not retired, it doesn't matter. I think to that effect, continue to participate in the dialogue and expressly share your opinion, I think is very, very important, so that we are in a position to. Yes, in such a case, we move on to the next thing, and we have time, madam. Sharp. Okay. No. Please sit down. Normally, in my conference presentations, etc., what I noticed is, normally in the beginning, madam sits there. In the beginning, first and fifth minute. Then she goes and attends to work, phone call, office, seniors, etc. Just before closure, she comes in the front. You know what? Indicate Jogara. Therefore, that is required. Madam, same thing I did in National Law School whenever a conference was held. In fact, I used to wave like this. Then the speaker, yes, we are closing like that. Now, I will introduce couple of things, then we will have discussion post lunch, okay? Because we have time. Damage to public property. This is first session which we are supposed to start post lunch, but we got time. Therefore, emphasis on new offences under BNS, namely organized crime, terrorist act, Deshdroh. Deshdroh word is, why I used is one commentary used. That is the only thing. But Deshdroh is nothing but the new offence in place of sedition. That's the, okay. Act endangering sovereignty, unity, and kind of thing. Snatching, mob lynching, etc. These are the specific offences we have. Now, 324, why I mentioned is, in fact, it is not a newly, what you call, carved out offence, drafted offence. It is already there, mischief. Mischief whenever the kind of thing. But I think the way the damage to public property, there is a need for emphasis to be given. That is the reason why I brought from that chapter here mentioned, saying recent experiences of where public property is damaged. Consequently, I don't think, you can't be a kind of thing that, no, let it happen, chalta hai, anything can happen. No, you need to specifically address that. Therefore, it is necessary and kind of thing. Particularly, the part, explanation 1, I want you to be very, very careful. It is not essential to the offence of mischief that the offender should intend to cause loss or damage to the owner of the property injured or destroyed. It is sufficient if he intends to cause or knows that he is likely to cause wrongful loss or damage to any person by injuring any property, whether it belongs to that person or not. It has nothing to do with ownership, please know. It has nothing to do with private ownership, public ownership, anything. I think that's very, very important, which needs to be. This is one important thing. Petty organized crime. Even now, in the sense, after so many times reading, in the bill format we have read, and when Sanhita made into act, that also we have read. I am unable to really understand what is the need for creating or defining this offence. I mean, normally what policy guidance we follow generally, please think and let me know. An offense is to be defined where the existing law or laws do not reflect that definition. Existing law or laws do not reflect that definition. Therefore, there is a need. Second important thing, not only either law or laws do not reflect, there is a need contextually, socially to address that. This is what legitimate justification, what I was talking about, criminalization. And the third, the most important thing is following all the principles of strict construction, maximum certainty, blah, 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 when you define. These are the three things. This one, first let me read. Are you familiar with surrogacy law passed in this country? You are familiar? Huh? Act, Surrogacy Act. You have read? Renting womb, etc. In that, there is one section, I have read at least 5,000 times. I did not understand the meaning. It says, a woman who is married forever. Married forever. No, means what? No, married forever means what? I understand married woman. I understand. Married forever. Not? Not? But permanent. Madam says permanent marriage. Permanence is a matter of mind between them. Okay. I mean, there are many, my own family, your families, there are many people who are not divorced. Right? Institution of marriage, compatibility. But what I am saying is the person who drafted the law. No, I am not talking about his marital status. No, please don't mistake me. It's too personal. I cannot. But even if it is foreign, law is meant for Indians. Somashekar sir recalled, before coming to this class, one observation by Justice V.R. Krishna Iyer, when he mentioned, exact words I cannot repeat, 10 Downing Street cannot understand either Muhammad or Manu. You know means what? 10 Downing Street means London, Prime Ministers. They cannot understand either Muhammad, that is Muslim law, or Manu, the Hindu law. What I am saying is, I understand it may be, but in terms of language, married forever. I mean, see, you are judges, prosecutors, you have that capacity, and I can't pass judgment on a person. My only request is, what made him to use that word? I'm sure there must be a intention or purpose. What is that? I thought I'll just share with you. It is something like a... Maybe. But I thought before lunch, this is a food for thought for you. So that, think about it. You know why we may not be able to, because last 3 years I was searching. Except meeting that person who drafted, I asked everybody. Maybe. See, my point is that could be the intention, I agree. But, I will put it this way. Say, for instance, any kind of communication, either oral or in writing, casual, formal, whatever. the words what you use normally indicate what is that you want to communicate. Am I right? That's what. Correct, no? But many times what I intend and what I want, I use may not be received by the reader or the person who is the listener in the same way what I want. That's where the communication gap. Here, it is not oral, it is in writing, law. Even then, that is the reason why I always feel whenever we write something in terms of what is that the reader would appreciate, I think that we need to keep in mind. What you intend, what you communicate must be received by the person same. I think that is the, here, forever, sir, forever, well, petty organized crime. Therefore, I mean, when you use a word, many people told me, no, Jogara, what said is correct. I asked, maybe, tell me the reason. The punishment you look into, he said. Organized crime, punishment you look into, this is petty, because the punishment is 50% of that. How far, to what extent? I think it's a very important question to be, okay? With this, we conclude now for lunch. Am I on time? Very good. Then what is the time for lunch?
Thank you, sir, for giving us a detailed insight and enlightening on the scheduled subject. We will resume at 3 p.m. for the post-lunch session to hear continued lecture of sir on the next topic. Thank you.
Good afternoon, friends.
Good afternoon, all. On behalf of Karnataka Judicial Academy and all the respected judicial officers and prosecutors present here, I once again welcome our today's resource person, Professor Jogarao, for the session. I request, sir, to continue his lecture
Sure.
on the scheduled subject. Thank you, sir.
Thank you. ಬಟನ್ ಹಾಕಿದ್ರೆ ಪರವಾಗಿಲ್ಲ ಸಾಕಾಗುತ್ತೆ. ಇದು ಫೋಲ್ಡ್ ಮಾಡಿ. ಎಸ್, ಥ್ಯಾಂಕ್ ಯು. Good afternoon, friends. Before we commence, I thought I'll just share with you something. When Mr. Satish shared the timetable about the sessions and asked me for a date, when I saw the timing, I was a bit worried. Because there is a session after lunch. Not for me, for you. I thought somehow I will manage and skip. I'll say something, some reason or the other. But when I hear Satish's voice, I can't do anything of that sort. He is so nice. I thought, let me engage post-lunch session. But whenever I engage a post-lunch session, I normally share one quiz question. This quiz question was shared with me by Honorable Justice M.N. Venkatachalaya, former Chief Justice of India Supreme Court. When I was in National Judicial Academy, Bhopal, addressing Honorable Supreme Court judges. Honorable Justice, before, then also post-lunch session. Then he said, Jogara, wait. I'll ask one question. The question I'm asking you now. If any one of you know the answer, you have to maintain silence. Because only I am going to answer. Okay? Clear? Suppose none of you are aware, that's excellent. The question is as follows. What is the difference between a mother of a child and a professor? I repeat once again, what is the difference between a mother of a child and a professor? Sir? Sorry? You know that. Then in such a case you have to keep silent. Can anybody raise a hand and say that I don't know the answer? Nobody wants to do that. No. May I tell you one thing, Sahebre, Mr. Somashekar forgetting. No? Your memory strength, I know. Okay. Mother of a child? No. He is absolutely right. A mother of a child can put only one child to sleep at one time. But whereas a professor can put the entire class to the sleep, particularly if it is a post-lunch session like today. Therefore, I am worried about you, but I am sure we will see what best we can do. And just to give a recap, we started off today pre-lunch session where we have introduced about certain propositions which needed to be kept in mind when we talk about criminal law making, the constitutional prerogative of the Parliament and Assembly. Also identified the principles which need to be considered while drafting criminal laws. We looked into changes at a glance. We examined certain specific aspects which they brought into Sanhita. and also explained about the things with regard to certain chapters, additions, deletions, reorganization, etc., etc. In this post-lunch session, we have already commenced particularly mentioning and detailing about how drafting a criminal law, please remember, how drafting a criminal law, even a punctuation mark may change the intent of the objective. Therefore, not only the word or letter or phrase, what you use, it must be after detailed caution. Then I gave example of surrogacy law about married forever, and I mentioned about one important offense which has been introduced, that is a petty organized crime. Organized crime we will come later. Please remember, the word petty, in my opinion, is inappropriate. If you ask me what is appropriate, I think the offense of this nature itself is inappropriate. It can be a part of organized crime, where you can distinguish in terms of the gravity a lesser punishment. Somehow that has not been done. But in the process while doing, let me explain to you the problems what I face, either as a lawyer or as a teacher. For example, you see the scope of petty organized crime. Scope. Member of a group or a gang, either singly or jointly, commits an act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, or selling public examination question papers. Then comes the bombshell, or any other similar act. This is a criminal law. Or any other similar act, criminal act means what? No. What I'm saying is, the intent is there, you want to extend the scope by using or any other similar criminal act. You know what essentially you are doing by incorporating that kind of phrase? You are making investigator as the draftsman of the law. You come later, as judicial officer, prosecutors, you come much later. But investigator officer decides. According to me, that is the similar criminal act under this institute. Where is the check and balance? What is the need for that kind of inclusive definitions? Please remember, we normally find in civil enactments, Sale of Goods Act, Transfer of Property Act, Negotiable Instruments Act, etc., etc., but not in a criminal legislation. Why? Strict construction with maximum certainty the law must be defined. That is at one level. The other thing is explanation. Theft includes trick theft. Can anybody tell me what is a trick theft? Okay. You draw the attention of a person for a particular purpose. In the course, you do that. Suppose, assume, what you said is agreeable. Assume. I agree. Suppose if trick theft is not there, does it not constitute theft? Then what is that abundant precaution by using that? Like what? Give me an example. What? No. WhatsApp chatting, trick theft. See, I discussed with many people. See, first thing is two things. I should know what is my weakness first, before I knowing my strength. If I don't understand, I should ask people, what do you think? The way I asked and our officer has responded, like that many people responded. Then in the light of which I look into, does that justify usage of that word? Because whenever a word is used, it should serve a purpose. This trick theft is not defined. Whenever you use a word, which the meaning of which you leave it to the investigator or including honorable judge, some guidance, something should be there. For instance, Indian Penal Code 1860, one of the most notable features is illustrations. Illustrations guide us a lot. You as a student of law, I as a teacher of law, and you as a judge, I as a practitioner, we learn a lot by reading illustrations. Illustration does not form part of the law, but it is a guiding force. You just look into how many new illustrations have been added in Sanhita. Just have a look at it. All old illustrations have been retained. I think that is something. On one hand, using a word, you don't define. On the other hand, you assume that others know. I am saying others knowing will be varied understanding of the same thing. That is a problem. Over. Theft from vehicle, dwelling house or business premises, cargo theft, pickpocketing, theft through card skimming. You mentioned, no, electronic, that comes here. Card skimming, credit card. Shoplifting and theft of automated teller machine. I mean, ATM is not subjected to theft normally because you have to do a lot of things to carry it. The cash only you take it. Not that people have not attempted. People have attempted. I mean, they attempt anything and everything to carry, including the entire cabin also they will take. But my point is that usage of expression. Over. Whoever commits any petty organized crime shall be punished with imprisonment for a term which shall not be less than 1 year. Which shall not be less than 1 year, but which may be extended to 7 years. Normally, I mean, when I say normally, it is something generally we think. 7 years, maybe 3 to 7 years. That a reasonable fare kind of. Here, you say shall not be less than 1 year. By doing that, what you are doing, honorable judge will have a lot of dilemma. 5 years, 7 years may not be possible. Then why not I finish it off 1 year? And if that is the case, petty organized crime has a petty punishment. The kind of things which you are referring, the kind of offense doing, crime doing, doesn't proportional to the punishment that is prescribed. This is the reason why I always advocate for judicial discretion when it comes to sentencing. Very, very important. Extenuating circumstances, mitigating circumstances. In fact, Honorable Member mentioned a very important thing. That's what we always, whenever we interact with judges, trial court, etc., we mention sentencing part is as important as recording conviction. Sentencing comes only after convict, no? Otherwise there is no thing. But it is as important. Honorable Supreme Court made it very clear. If necessary, you adjourn the case and post for a sentencing hearing. Why? Because the appropriateness of the sentence, which must be proportional to the crime committed, the criminal and the gravity. Please remember the victimization as well. All the factors you take into and you identify. Please believe me, remember that is appealable in nature. You don't worry about it. Whether it is appealed, insofar as your conscience, whether you have done, as a result, a balancing. That is something doesn't. I mean, my only concern is, on one hand, lawmaking is made with a, society needs this kind of thing. Maybe. I don't dispute that. But the method and the way in which it is drafted and sentencing what is prescribed, much to be desired. I think that is something we need to. Particularly, my concern is, or any other similar criminal act. You can't have such a kind of thing, etc. I hope you recall Section 67 Information Technology Act, Honorable Supreme Court judgment struck down. What is the doctrine the Honorable Supreme Court is invoked? Doctrine of void for vagueness. Void for vagueness. That is a very important doctrine where if the constructed, the defined offense doesn't carry the wrongdoing in specificity, it must be struck down. I only hope that these things need to be taken into consideration while drafting. Okay? This is about petty organized crime. Then comes organized crime. My dear friends, organized crime runs into not paras, pages. Organized crime, if you look into, it's one of the most important offense. In fact, Somashekar Garu asked me one simple doubt just before commencement of the session. He asked me, how come these three offenses are in offenses against human body chapter? Am I right? It's an important question because all the three, petty, organized crime, terrorism, basically economic, organized offenses kind. Why? I said, first I also got such doubt. But when I read the definition of the offense, I felt bodily injury is one of the consequences. They have kept it in the offense against human body. That's what I shared with you. That's the only thing. But otherwise, if you look into, just 1 minute. One second. Theft, snatching, cheating, unauthorized, etc. Where is the body injury? Come. All dwelling, these, etc., there is nothing. But please remember, the potential bodily injury cannot be ignored. Only on that ground alone, we may argue or endorse saying that this is in the chapter. That's all. Snatching, definitely without bodily injury it cannot be done. I mean, whatever, unless the person gives it. No, somebody they threaten, why unnecessary kind of thing, etc., take it, go. Then, but otherwise it is. In all other cases you don't find. Correct. I know, that's correct, absolutely. But my only point is, that is depending upon the particular nature of the offense. Yeah, that's true. Correct, definitely. Now, my only point is, only that particular offense, that's what I'm saying. But other offenses, potentially there may be a bodily injury. For instance, you need to be a bit patient because in this couple of things I need to discuss. But the definition itself is quite what you call important. For instance, any continuing unlawful activity. You remember what is a continuing offense? Existing. Already started, it's continuing. Give me an example for continuing offense. You are right. That is regulatory compliance. You are right.
I think view is taken in such cases.
Correct.
No question of limitation.
But any other offense against human body? Is it a continuing offense? Mental. You are absolutely right. When we talk about harassment, it is not the specific sporadic incident. The continuity may have implication for either physiological or psychological, or both. Any other? Kidnapping is a continuing offense? Okay. But I thought there are 3 different offenses. Kidnapping, wrongful confinement. Correct. Okay. They kill. You are right. You are right. That's what we have seen. Even I'm not talking movies. Even real life, these things. Even Bangalore, we have some experiences like that.
Loss of property, then loss of mental stability. It's a form of mental injury.
Mental injury. The reason why I am asking, let me make that also clear. So that here it says any continuing unlawful activity means what? No, continuing. No. Started, origin, continuance, termination. RPD, ಜ್ಞಾಪಕ ಇದೆಯಾ? Right of private defense. It originates, it continues, and gets terminated. Same thing. But I am saying the word used is continuing. Suppose I do a particular offense which comes under organized crime, but only once I did. It's not continuing. Then what happens? The reason why I am asking is, I know, but the reason why I am asking is, why did you use the word continuing? In such a case, okay, in such a case, I don't repeat, then what happens? See, what is the purpose of defining? I mean, there must be a purpose, right? The purpose, I am only asking, by not including continuing, whether purpose is defeated. Or, if you say the word continuing should be there, in such a case, what is the process of investigation and what is the process of evidence? That is what is to be understood. Then only will be. No, but a criminal offense limitation, as you know, it's only depending upon the thing, etc. But otherwise, correct. But that they have not used. See, for example, the definition of act, it includes series of acts. It is there even in Sanhita. But that's what you are saying. My only concern is the law, when you define, if you gives a kind of opportunity for anybody to wriggle out. But one thing, habitual offender, first time I am committing successfully, what happens? No. I have a gang. First time we have committed, successfully committed. Thereafter we are reformed. We are saints. Then what happens? Correct, but there is no continuing unlawful activity. How threat I cease to commit an offense, no? Okay, I agree. My only point is, the word what is incorporated, is it with a specific purpose? If so, what is it? Suppose by dropping that word, whether purpose is defeated. That's all. You just go through the other avenues also. Continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing. I told you, no, land grab is something in newspapers you read, because we have many people who are into this activity. Not only Karnataka, various places, because land is the most appreciable value. Therefore, grabbing is easy, buying is difficult. You got the point. Therefore, but what is land grabbing? That we do not know. The law does not define. Contract killing. This is something because of Bollywood we are quite familiar. Supari. Therefore, we are quite. Why only Bollywood? Every wood, every collie, tolly, molly, all. Correct. Absolutely. Absolutely. Correct. As a result, that I understand. Economic offense. That is again. What is okay? Maybe from law commission reports, etc. We may draw some inference. Cyber crimes, trafficking of persons, drugs, weapons, illicit goods, services, human trafficking for prostitution or ransom by any person, a group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence, threat of violence, intimidation, coercion, or any other unlawful means to obtain direct or indirect material benefit, including financial, shall constitute organized crime. See, normally what happens is, I always felt that drafting laws is such a specialized skill where the person must really, but here what I understand, it's called name dropping or word dropping. There are so many words because you are so much worried that anybody may corner and get it. Therefore, you want to include so many. Whether the purpose is served by using those words, that is something. And please remember, for the words what indicated, for example, organized crime syndicate, they define. Similarly, continuing unlawful activity. Now come to it and read and come back to my question again. Means an activity prohibited by law, which is a cognizable offense, punishable with imprisonment 3 years or more, undertaken by any person, either singly or jointly, as a member of organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years. And the court has taken cognizance of such offense and includes economic offense. Now you understand. See, I understand their concern the society is facing because organized crime is a reality and it is a great social menace. One has to admit that. But is this the way which requires to be? Economic offense includes, please remember, criminal breach of trust, forgery, counterfeit, currency notes, bank notes, government stops, hawala transaction, mass marketing, fraud, or ruining any scheme to defraud several Ponzi schemes, okay, or doing any act in a manner with a view to defraud, etc., etc. Whoever commits organized crime shall, if such offense has resulted in the death of any person, sir, death as a consequence, be punished with death or imprisonment for life, and shall also be liable to fine which shall not be less than 10 lakh rupees. In any other case, be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to, etc., 5 lakhs. Whoever abets, attempts, conspires, etc., etc., imprisonment for life. Continuing. Any person who is a member of organized crime syndicate shall be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, shall also be liable. Here, please remember, belonging to a gang. That's all. That is enough. Something like a group liability. Whoever intentionally harbors, conceals any person, etc., etc., shall not apply to any which it is also a very, very serious offense. Whoever possesses any property derived, etc. All this is vis-a-vis PMLA, Prevention of Money Laundering Act. You know, Prevention of Money Laundering Act always has a subjective offense and a predicate offense. Therefore, for example, I indulge in trafficking of drugs. Enormous cash in currency I get. What do? I need to launder it. Therefore, I indulge. Therefore, PMLA is a very important institution. There is no doubt about it. Okay, etc. And again it says, if any person on behalf of a member of an organized syndicate at any time has been positioned to movable or immovable property, this is the DA, disproportionate assets. Okay? In other words, organized crime is something in comparison to petty organized crime, if you look into. The question what I had asked, the kind of other similar criminal act, that kind of phrases, etc. Is there a need for having petty organized crime? Not less than 1 year, but 7 years, extend up to 7 years, etc. If the organized crime is in such a manner, please move on. If petty organized crime can also be a part of it, that is a better way of, etc. As a result, what happens is the investigative officer and the prosecutors and the judicial officers, they are in a different position to understand the efficacy of the law. But their own wisdom, they thought this is a better option, they have done it. Therefore, we need to really take this into account. Now, in the light of this, before we come to this, 1 minute. You remember I mentioned about organized crime, superintendent, etc., who is given power to decide. That is not organized crime, that is terrorist. That's the reason I want to check. Let me, terrorism. Till date, substantive criminal law have had no provision about terrorist. No doubt we have successive terrorist-oriented legislations in the parliament, etc. And currently we have a very important legislation dealing with terrorism. Whoever does any act with the intent to threaten or likely to threaten the unity, integrity, sovereignty, security, economic security of India, or with the intent to strike terror, likely to strike terror in the people or any section of the people in India or in any foreign country. Foreign country is very important because of our own experiences, particularly of recent past. Okay? By using bombs, dynamite or other explosive substance, inflammable substance or firearms or other lethal weapons, poisonous, noxious gases, other chemicals, etc., whatever likely to cause. Okay. Death of or injury to any person or persons, loss or damage to destruction of property, or disruption of any supplies, services essential to the life of the community in India or in any foreign country, damage to the monetary stability of India by way of production or smuggling or circulation of counterfeit Indian paper currency, coin or any other material, or damage or destruction of any property in India or in a foreign country intended to be used in the defense, etc. All these things very clearly indicative of the terrorist act as an offense. The question, which is in a way a repeat question, where is the need for such an offense in Sanhita? When we have a dedicated legislation dealing with terrorism. This is what mainstreaming of the law. Terrorism is not a kind of regular routine offense. No, it is something which strikes at the basic roots of the country. Therefore, must be handled with iron foot. There is no doubt in that. But even then, you need to provide whatever that is required, etc., etc. The question is, when you have a dedicated legislation, where is the need for this particular, and how do we justify? How? For the purpose of this section, public functionary we have defined, counterfeit Indian currency we have defined. Whoever commits a terrorist act shall, if such offence has resulted in death, be punished with death or imprisonment for life and shall also be liable to fine. So long, I am talking about 1860 Indian Penal Code, the punishment always in response to the seriousness or gravity of the offence. But in Sanhita, a different approach is being mooted. What is that? If the consequence of crime commission is death, then the person must be punished with death. That is something, a very important approach. Maybe the government is justified in their wisdom and thinking, stating a person who took the life of another person must be given a sentence where others don't indulge in future. It's called a most effective deterrent effect kind. Possible. There is a possibility. But that approach is something new, please remember. And depending upon the consequence of the crime commission, the sentence gets changed. That is the example. For example, in any other case, be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to. In any other case, be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to fine. Clear? You take this sentence and compare with this sentence. If such offense has resulted in the death of any person, be punished with death or imprisonment for life and shall also be liable to fine. You understood? This is where the issue of proportionality in sentencing has been ignored. Each word we need to then compare. Then you will be able to appreciate it. In my opinion, if at all you say life imprisonment there, all other cases, it shall not be for life. If you include life imprisonment there also, where is the proportionality? How do you justify as a judge a person who indulged in terrorist act, killed somebody, and a person, he did not kill somebody, but injured somebody. Okay? For both you give life imprisonment. How? How it could be rational? I think the emphasis more on the gravity of the offense without commensurating proportionality, I think is a weakness. Constitutionality can be challenged. Whoever conspires, etc., all the things, I mean, you know, I don't think there can be any complacency or a misplaced sympathy with a terrorist. No, security of India and community interest matters and should matter. There is no doubt in that. Explanation. For the removal of doubts, it is hereby declared that the officer not below the rank of superintendent of police shall decide whether to register the case under this section or under the UAPA. On one hand, you say you mainstream the offense and you justify that there is a need for such an offense in Sanhita. On the other hand, the power you give it to the superintendent of police to decide whether charge sheet is to be filed under this act or another. Now, what is the message we are conveying? Another thing, very honestly, another thing I am asking a simple question. I want to know on what basis the superintendent will be able to decide. What is that basis? I am sure he must be IPS officer. That's fine, no problem. But what is the basis? Where is the guidance? That is the problem. That is the problem. My only point is that these ramifications should have been addressed and discussed. We were in such a hurry to pass the law. We will pass the law because nobody else to defeat that law. We will, but sound discussion, consultation. In the light of this, we come to the new offense. We have informed Honorable Supreme Court also that about offense called sedition, section 124. We said we have repealed. Yes, repealed. 124A. But a new offense has been created. The new offense is dealt under section 152. criminal law teaching, particularly the scheme of culpable homicide not amounting to murder, 299 to 304 if you read, you understand how the scheme has been presented. Here also that kind of analysis is necessary so that we will be able to make out. For instance, it reads as follows. Whoever purposely or knowingly by words either spoken or written or by signs or by visible representation or by electronic communication or by use of financial means or otherwise excites or attempts to excite secession or armed rebellion or subversive activities or encourages feelings of separatist activities or endangers sovereignty or unity and integrity of India or indulges in or commits any such act shall be punished with imprisonment for life or with imprisonment which may extend to 7 years and shall also be liable to fine. You remember the offense law of sedition had a checkered history in terms of what it constitutes. I am talking about Kedarnath onwards. And ultimately, when challenge is mounted before Honorable Supreme Court sought the views of central government, what they think, etc. I mean, a couple of times they said there is a need for this offense, and a couple of other times they said there is no need for sedition, etc., etc. And ultimately, a kind of information has been taken. My only observation, after a lot of thinking, I am sharing this observation with you. The word sedition is not used, does not mean the offense is repealed. Particularly the way this particular offense. I'll just bring my concern. Encourages feelings of separatist activities, subversive activities. In my opinion, what is the punishment? It is life imprisonment or extend to 7 years. Cognizable, non-bailable. And the kind of time that is taken for whatever, the disposal, blah, blah, all those things if you take. By saying this, I am not holding brief for a person who threatens integrity of India. No. A person who threatens integrity of India must be punished. But my only point is, it should not be a matter of slippery slope interpretation by the investigating agencies. They need guidance. Otherwise, the liberty is at stake. In my opinion, on one hand, the scope appears to be narrow in terms of the specific usage of words and phrases. But if you focus on those words and phrases, it indicates the scope is very wide. If the scope is very wide, the room for misuse is stark reality. I think that is something requires to be taken note. Maybe in a kind of either High Court or the Supreme Court, guidance, if it is there, I think we will be happy to. Otherwise, possible misuse or potential misuse is writ large, which under any circumstances must be. Correct. Mike.
Ultimately, at one point of time, we may find that though the exact words used in 124A are not found here, for a common man who knows English,
Correct.
I think that he should be able to say that 124A, in our legal minds, we make that subtle distinction, leave it.
But a common man.
For a person who knows a bit of English,
Correct.
or if it is translated into some vernacular, he may find that 124A and 152 not so much of a difference. That's what to my mind appears. I have to apply my mind again. I just want you to help me in understanding this.
If you don't mind, why don't you read 124A once again?
All right.
Please read. Can you read now?
Later.
Please.
Let's proceed.
No, you read.
whoever by words,
Hmm.
either spoken or written,
Hmm.
of course there is something here purposely doing, etc.
No, don't worry. First
we'll go
read
to- all right.
124.
Or by visible representation or otherwise,
Hmm.
brings
Hmm.
or attempts to bring into hatred or contempt,
Hmm.
or excites or attempts to excite disaffection towards the government established by law in India,
Hmm.
shall be punished with so and so.
Hmm.
Explanation: expression disaffection includes disloyalty and all feelings of enmity.
Hmm.
Explanation: to comments expressing disapprobation of the measures of the government with a view to obtain their alteration by
Nothing
lawful
wrong
means,
in that.
etc.
Hmm.
Explanation 3: comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred. Here, this
That is 124A.
Yes,
Is there a word to indicate mens rea?
in 124A,
Hmm. Whoever,
by words either spoken, written, or by
there is nothing like purposely or knowingly.
yes,
Okay?
illegal.
Next, hatred word is there? Not there. Here. 124A.
ಗೊತ್ತಾಯ್ತು 124 ಏನಲ್ಲಿ ಹೇಟ್ರೆಡ್ ಇದೆ
ಇದೆ. But you don't find in
152
okay?
Yeah.
Now, these are the major things.
ಮೇಜರ್ ಥಿಂಗ್.
But now, if you look into the words that have been incorporated here, do they give a narrowly constructed meaning? For example, you say subversive activities.
ಎಸ್
Then what is the definite meaning? Subversive activities means. If it is definite, what is the definite meaning? See, in criminal law, on one hand, when you use the word, you need to define. If it is, there is a need for definition, if it can be defined, number one. Number two, if not, at least provide some illustrations.
Subversive obviously implies an act against the established system.
Yeah, my only point is, I conduct a protest.
Conducting protest is a part of speech
The-
expression. Even protest in a prescribed or recognized manner, as per rule, is not a act of subversion.
Subversion.
Subversion is aggravated form of being so rebellion to the established system or law.
Yeah, but that is what, where do I find that expression? You are saying, I am the investigative officer. I can't consult you every time. I want to put somebody inside. As a result, my only point is, fairness demands, let that be as far as possible, is commonly understood by people. I agree with him. This is what could be the, suppose if you ask me, I will also answer that way. But I am saying guidance is necessary. For example, encourages feelings of separatist activities. It is definite. For example, a particular region of the state, they want a separate state. Does this amount to 124A? In my opinion, it should not. In fact, entire India divided into several states after so many deaths and riots and, for example, Andhra Telangana, the recent bifurcation, or 10 years before, I think. Therefore, what I am saying is, you need to have the specificity which is missing. And endangers sovereignty, unity and integrity. This is something again a very, very vast meaning, scope, which is basically very difficult to pinpoint that this could be. My only suggestion is, why did we repeal 124A? Number one. Correct. Correct. Repealing 124A. But keeping sedition, you could have added that India word, no? Keeping 124A, amend it, put Government of India there. What is the problem? No. Why? Because every one of us, we are aware how the enforcement of Section 124A has been grossly misused. In fact, we got to such an extent, we started keeping silence. We are not sure. I think that's the problem. Here, the explanation I really appreciate. Really appreciate. You know why? It mentions clearly comments expressing disapprobation of the measures or administrative or other action of the government is the view to obtain their alteration by lawful means without exciting or attempting to excite the activities referred to do not constitute an offense under this section. Because in a democracy, protest is a matter of right. I don't agree with you. I think I am entitled to say that I don't agree with you. I mean, what happens when somebody will throw stones at my home and what happens to my daughter, I do not know. What can I do? Therefore, option keep silent, or I think somebody has to speak. I think this explanation is very important. So that at least investigative officers, they look into this is what they are doing, therefore it does not come under, it comes under the outside the ambit of the, I think that's very important. But having said, celebrating repeal of Section 124A is masked by incorporating this offense. Therefore, we need to really look for kind of things, why did we repeal on one hand and introduce the other. Major thing is many of writers, activists and professors, including myself, we always said in an independent India, sedition cannot be an offense because sedition was used by Britishers when they were ruling against their state, British government. Therefore, here, therefore, we feel there is no need. And so many other sections, waging war, blah, blah, are there. But again, incorporating this section, I think we need to have a kind of mob lynching. This is one important offense which Government of India, Honorable Supreme Court of India, as you are aware, informed state, central government to pass adequate laws, because at one point of time, mob lynching became a fashion. I mean, many friends, they used to, are there no authorities like police in this country? Are there no courts? Nobody is taking note of it. Why it is happening? And people generally, they lack respect towards the law. Everybody, they think that they are entitled to take the law into their hands and they can do anything, whatever they want. Is this a kind of public? I think that is something very, very important. I mean, particularly certain areas of certain parts of India, I don't want to name, you know that, the kind of the high intensity moral policing what we witnessed. Therefore, I think all these things led to individuals taking law into their hand. I think that should be. Therefore, it is very welcome. There is nothing wrong in that. The only point is, whoever commits murder shall be punished with death or imprisonment for life and shall also be liable to fine. I do not know, for offense labeled as mob lynching, why the word murder is to be used. Suppose, if murder is used, let me just explain, imprisonment for life and shall also be liable to fine. But what is the punishment for murder? Death or life imprisonment. Which means if 5 people kill one person, I can escape death sentence. Where is the rationality? When a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, etc., they are not liable to fine. Which is nothing but dacoity as to property, mob lynching as to human body. 5 or more. But where death is not there. But you say murder. Mob lynching, essentially, sorry. Yeah, but murder requires mens rea. But my point is, mob lynching, generally what is understood, I don't think this is something a casual killing or some killing. No, people know what they are doing. My act of, definitely, my act of slapping or kicking, etc., may not lead to death, but collectively all the injuries more than enough for the person to die. Therefore, that is what is the thing. But using the word murder, causing death, whoever kills, kind of reduce punishment, something like that. I think that's where I feel, in a way, certain offences contradict some other offences. The entire parity you look into, it's lacking. I don't know why, very honestly, but I think it requires to be examined, the reason. And as and when possible, remedial measures must be incorporated. This is something I personally feel the most important development in this Sanhita, fake news, because we have reached a stage where, I hope I'm not including every one of you, but generally I'm saying, please don't mistake me. For us, life without WhatsApp is no life. Morning we get up, 6 o'clock. First thing is mobile. Tuck, 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 tuck. Lecture is over. Tuck, 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 tuck. Group messages, individual messages, photos, celebrations, status, and DPs. DP means display photo. Every 1 hour you change. I go mad looking at those people in my own home only. Therefore, after getting up, till I complete walk, I don't even look at mobile. First thing is, I myself get irritated with my own behavior. Others much more, forget about it. I can't handle life like that. I need my own space, etc. But fake news, the origin and continuity and widespread spread is because of. And as a result, many people's lives and some people's reputation, character assassination. You know only one thing. My friend forwarded one message. Then I asked, did you read this message? He said, no. I asked, did you read? He said, no. Then why did you forward? You will read, no? What is that message? It's something about some personal something, etc. Why should I spend my time on, I don't have time about my own personal thing, and I must read somebody's X, Y, Z, these. Then I told him, at least read before forwarding, so that you don't forward. Our lives are like that. Luckily for you, judicial officers and public prosecutors, morning 10 to evening 6, no problem, because you are in your office. But we, the lawyers and teachers, the moment case is over, we come out and do it. And teachers means the moment class is over, we'll do it. Therefore, I think this is a very important thing. And I always say, you indulge in communication, but it must be responsible communication. Always. Responsible communication is such an important thing. And the fake news is whoever by words, either spoken or written, by signs or visible representation through electronic communication or otherwise, makes or publishes any imputation that any class of persons cannot, by reason of their being members of any religious, racial, language, regional group, caste, community, bear true faith, allegiance to the Constitution of India as by law, etc. Asserts, counsels, advises, propagates, or publishes that any class of persons shall, by reason of their being any members of the religious, racial, etc., can be denied, deprived of their rights as citizens of India. Makes any, etc., it continues, misleading information, etc., and places of worship. Majority of these things turn around faith, religion, community, these, that, etc. Then comes suicide. As I told you, the word suicide is inappropriate. It should be attempt to commit suicide. Because suicide is not a punishable offense in this country. Even in Sanhita, it is. The only thing is, here, as I told you, 226, there is a segregation. The segregation is as follows. 226 only deals with a particular attempt leading an objective. What is that? Compel or restrain any public servant from discharging his official duty shall be punished. Simple imprisonment, etc. Please remember, intent to compel means rea. Intent. But the punishment, if you look into, which may extend to 1 year, or with fine, or with both. Maybe that is, there is no doubt in that. But my only point is, the particular compel or restrain any problem, that must be very clearly established. If not, please remember, the very person will be subjected to criminal prosecution without any, because the other suicide, attempt to suicide, is no longer a criminalized act. Because the person, etc., subjected to psychiatric care under Mental Health Care Act. I think these two, one. What do you think? You think this kind of offense, is it required in our context? It is required. Because several incidents, whatever I have read in media, etc. Correct, correct. Yeah. No, that is also there. Or ask him not to do anything adverse. That is also possible. I mean, these things, I always feel many people, they threaten or take law into their hands to seek a favor. Is this water you are saying, sir? Correct. No, normally, I always encourage people, if you have a doubt, seek clarification. Because morning I saw, I did not. Again they started. And they are not coming up. That you noticed. They are not coming up because 2 bottles are here. No, I'm just joking. If it is tea or coffee, I would have gone down and taken it. But now it's water only. This particular segment, I want to start with one particular observation made during Lok Sabha debates. The objective is to seek justice, and punishment is a matter of sentiment, so that commission of crime is discouraged. That's the kind of... As I mentioned, crime or offense and punishment, both, they are 2 sides of the same coin. There cannot be an offense without punishment, there cannot be a punishment without offense. Absolutely. But both are interlinked. If offense, which is a criminalized instance of wrongful conduct or criminal conduct, the purpose is only served if appropriate punishment is identified and prescribed and awarded. If there is no such connect between these two, the purpose of criminal justice itself will be at stake. Therefore, I appreciate the commitment that justice must be, of course. But as in my propositions also mentioned, the ultimate objective of criminal law is to render criminal justice. But how do you do that? Through the offense wrongdoing and sentence. I think this is where what BNS captured vis-a-vis the punishment that we have to. Somshekhar Garu made a very interesting observation, which I truly appreciate. when he mentioned about summons, warrant, summary, etc. Technically, all the things may not be followed, etc. But by and large, these things are taken care of. What I want to know, Satish ji, idhar, Satish, banni. I hope I am not disturbing you. Cut his head. You remember that you will pose a question? That's the reason I called you. Just I will give you 1 minute time. Baithe, idhar baithe, na? You just wait for 1 minute. The reason why I ask this question is 235 clause 2, 248 clause 2, CRPC. New sections I don't remember, therefore. You strictly follow those rules, the interpretation. I'm generally asking. I'm not going to give any performance appraisal or something like that, nothing. Generally I'm asking. You remember 235 clause 2, 248 clause? Sentence hearing? Yeah, correct. Do you face any problems in strict compliance with that? What problems?
One sentence passed, that is allowed to ascertain it. What is just quantum of punishment in consideration of offense in question and the manner involved in this commission.
Correct.
While assessing what would be the just punishment within the scheme of the punishment it is provided, whether it is a simple imprisonment or a rigorous imprisonment or period of imprisonment, more than one offences are involved in
Correct.
the
Correct.
same offense.
Correct.
Whether those offences, incidences should be taken together, whether it should be go for a consecutive or a concurrent way, or if a same accused is detained and produced under body warrant, each period of AC should be considered set off. If he is convicted for the later offense for the first time, earlier in point of time, and the first offense in a later point of time, then whether the conviction of later offense should be taken in consideration for enhancing the sentence of a later
Early.
offense. These are the normal issues that we
Face. In fact, in the morning when I said about broader consultations, let me be very frank with you, sir. Only as a practitioner and interacting with officers like you, I could be able to understand. Otherwise, it is always within you and others we don't.
Another paradox is only some of the judges who are more involved with the convictions are only facing this. And popular judges are those who offer the acquittals whether reasonable or unreasonable with another.
That is the different.
Yes. And whether such unreasonable acquittals amounts to an abatement to the another offense, not at all brought into the question. That's not true.
In my opinion, this is the insight which needs to be discussed. The reason why I am asking is, as a professor, what I do, 235 class 2, tack, Supreme Court decision, tack, somebody's article, this is the thing. But your insight is never shared because we do not know. We are in dark. And you are in your own planet because your own time constraint, your disposal rate, your pendency rate, your this, your that. Forget about the capacity building. How to discharge your own capacity, nobody wants to know about a judge. Nobody. In fact, recently there were some comments also, no, vacation is too much vacation for judges, these, that. I'll tell you, that is something you need to understand. The reason why I am saying is sentence hearing is something, a very, very important component. Indian Penal Code had its own in the conjunction with CRPC, Sanhita also. But here the question is punishment scheme. What actually? Okay. I requested Mr. Satish only to raise one very important question. You remember before lunch, I did mention about community service. Under punishment section, if you look into, the community service is added. This is something I will come to it a bit later. Here, section 4, where it says death, imprisonment for life, imprisonment which are few descriptions, rigorous with hard labor, simple, forfeiture of property, fine, community service. You remember I did mention about the lack of guidance. When we say community service, what actually factors to be taken, etc. Mr. Satish has very important point referring to BNSS 23 explanation. Please.
I was discussing with sir during lunch hour. This new sentence we find in chapter 2, section 4, that is community sentence, but that has not been defined in BNS, sir. But an explanation is provided in BNSS under section 23, which says that community service shall mean the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration.
Very important.
That is what has been explained, sir. But what kind of community sentence that can be
Service.
imposed by the court is not defined, or nowhere it is explained. So while only for 6 petty offences,
Correct.
did
Including defamation. Drunken driving.
And government servant involving in a trade.
Correct. Kidnapping of a child.
That is not included,
no,
sir.
that-
No.
okay.
And 303,
Life convict.
another one, below 5,000 rupees, theft
Below, yes.
below 5,000 rupees. And as I said, the kind of community sentence that can be imposed is not defined, sir. So my question is that, what is the parameter that needs to be adopted by the court while imposing community sentence? Whether the socio-economic background of the accused is to be looked into by the court is not.
Correct.
Suppose if a doctor commits an offense, what kind of community sentence that we can impose?
Very good.
Or if an advocate commits an offense,
Correct.
what kind of community sentence that can be imposed? Suppose if there is a uniformity guidelines across
All
the
over
country, so there will be no disparity. That's what my question is all about.
Excellent.
Thank you, sir.
In fact, what Mr. Satish asked, I wanted to clarify. When I mentioned about the lack of guidance, please remember I was talking in the context of BNS. But BNSS there is. But there also, apart from saying X, but there is maybe A, B, C, D to Z, there is silence. As a consequence, his observation is, what is that community service? How do we ensure uniformity? Because there is no guidance. I am sure maybe Bangalore-based judge may give one particular community service. Mangalore-based judge may give another service. How do we ensure uniformity, parity? I think that's a very important question. What I want to like to share is, because drunken driving is there, no? Recently, I watched one movie where I think the lead actor and his friends, they were caught drunken driving. And they don't produce them before the court, etc., etc. After 5-10 minutes, or no, half an hour or so, somebody calls somebody, where are they? Then he says, why don't you go ahead and see? In some majestic junction, all the three, one with one placard, don't drink and drive. Another guy, placard, drive in a vehicle only when you have, what is that, RCB, what? RPC, what is that? DL, something like that. Book, RC book. He is saying RCB hogide. Royal Challengers Bangalore. This one and some other. don't this, that, etc. This for 6 hours. 6 hours because of drunken driving. I mean, what I am saying is, when I saw the movie, the question is this a community service? I felt in a way, bringing it to the notice, and that they have done it or not, I mean, people may definitely understand, there is not, but at least informing people. I am saying there are, like that there are so many activities. At least in terms of illustration, you give some idea so that. The only thing is, I don't want any kind of thing in terms of endangering or not endangering. I am speaking the BNS language, not endangering, compromising individual dignity. That is very important. About his whatever community, religion, those things personal we should not, and survey kind of thing. But that's where person to person there will be variance. Therefore, his observation, there is a need, even under BNSS also, some kind of illustration or some kind of thing if they provide. On one hand, parity. On the other hand, there is no need for very innovative kind of thinking, etc., etc. I think, thank you so much. Very good. None? ಹೌದು, ಬಟ್ ಇನ್ ದಟ್ ದಿ what she is saying, 355. Please look into that. BNSS or BNS? $355. Yes, yes. That is the next question. The individual says, no, I don't do. Then what happens? Yeah.
355 BNS speaks about misconduct in public by a drunken person. Whoever in a state of intoxication appears in any public place or in any place which it is a trespass in him to enter and there conducts himself in such a manner as to cause annoyance to any person shall be punished with simple imprisonment for a term which may extend to 24 hours or with fine which may extend to 1,000 rupees or with both or with community sentence.
Yes, you are absolutely right. This is not drunken driving, but post-drink causing. Yeah, yeah. I mean, they are not driving, but they are creating something. You are right, that way. And this is something like, you remember earlier we used to say, standing in the court in punishment till evening, till the rise of the court. Yeah. It is, you are absolutely right. But we don't say punishment, it's a privilege we say, because you are sitting. You are absolutely right. The only thing is, maybe specific to that kind of offense we have to identify what community service, etc. And our friend asked another.
When I act, the same connotation is being used.
Okay.
Community service.
Okay, okay.
So if the juvenile is punished, so they put into community service.
Okay, okay.
It's already done, sir.
Hmm.
I'm getting that act also. I have that in my mind.
Yeah, but no, in that statute, is there a guidance?
There is guidelines, even if you have passed such a sentence.
Ah.
Where school-going student has took his father's motorbike and caused the accident.
Okay.
His offense was 2 rounds.
Hmm.
And he was sentenced that AG police shall take him to at least 10 schools
Okay, okay.
to explain the incident so as to that they shall not take such an advantage.
Correct.
And another thing, one of the tribal boy, when I said 14 or 15, he was involved in the case. By 16, he was prosecuted. And he was sentenced that for 1 or 2 years, he shall assist the forest team in extinguishing forest fire.
Okay, okay.
And thereafter, he shall be considered for the appointment of watcher or a team or any
Very good, very good.
without considering all this order of conviction.
Very, very excellent. I think there are, we need to collate. We need to collate and make available so that we get to know the kind of, particularly juvenile I'm sure must be thought over the process, etc. Our friend,
No,
sorry,
after imposition of community sentence, who has to monitor it? That is also not clear.
correct, correct. And our friend is asking one more question. Yeah. Yeah, but law does not say so. I mean, his point is, as matter stand law, if there is such kind of clarity, it will be. But our friend is asking one thing. Whether a person who is awarded community service, can he say, no, I don't want to perform? Keep on? Okay.
Sir, good evening, sir.
Yes.
Sir, when I have worked as a chairman in JJ board, Tumkur,
Okay.
there is a provision under section 18 of JJ Act with regard to the community services concerned. If any child conflict law found guilty, we have right to send the child with conflict law to for community service. That is hospitals or in any government institutions
Okay.
to serve in there. It's with regard to the cleaning up, to assist the nurses
Okay.
to clean the hospitals, etc. and other works.
Okay.
There is a provision under JJ Act also.
Okay.
With regard to this community services concerned.
In
Section
such a
18.
case, I am really happy that you are bringing that insight. That insight requires to be collated and see in what way we can have guidance in this. Now, if he refuses, you say, what did you say? Default sentence. I mean, that's what even our punishment provisions also provide very clearly in case, for example, rigorous imprisonment, etc. Correct, that's the section. BNS. What does it say? Read.
The offence is punishable with fine or community service. The imprisonment which the court imposes in default of payment of fine
Correct.
or in default of community service shall be simple, and the term for which the court directs offender to be imprisoned in default of payment of fine or in default of community service shall not exceed 2 months when the amount of fine does not exceed 5,000 rupees.
Okay.
4 months when the amount of fine does not exceed 10,000 rupees.
Oh.
And 1 year in other case.
Okay, very good. If there is such kind of guidance in terms of default, minimum 2 months, that I think this is what I am saying. If this kind of guidance is there, I am sure we are in a better position to understand and enforce to make it purposeful. I think that is the ultimate goal. Now,
Assisting the resource person in the academy to get the books and other things.
correct, correct.
Something of that kind.
No, absolutely, absolutely.
Now, this JD Act itself was required.
Huh,
So I went there.
huh.
So some person is asked me to do some community service here.
Correct.
Just jocularly telling it.
No, no. I am saying these are the ways in which we can share ideas. That's what I am saying.
Sometimes when I meant it ironically also in the class. And I find there is no assistance.
I know.
That's a good
But do you need any assistance now?
No, I don't. I went there and got it.
No, but I'll ask him to assist you.
Yeah, because he is not from our academy. Here, academy. So I thought my academy people would be in a better position to.
I know, but lot of weight on your lap. No problem.
Yeah, I'm not a junior.
You are like juvenile only at this age. My point is, this particular punishments, if you look into the scheme as such, 4, 5, explanation to 5, etc., punishments, commutation, fractions of terms of punishment, sentence may be in case of imprisonment, wholly or partly rigorous or simple, amount of fine, liability, etc. All the details have been. Enhancement of certain offences, solitary confinement and limit of solitary confinement, everything has been mentioned. This is what is the nature of the punishment. There is no change except for community service. That also, the entire code, maybe 6 or 7 offences there is a mention. But I think there is a need for a particular clarity, guidance. And as other judicial officers mentioned, maybe under JJ Act or some other legislation, if we have some experiences, better we collate that. Yeah. Yes, yes, yes. BNSS 23 explanation. Yes, yes. Yeah, but there also, it is something like earlier Indian Penal Code. One second. One second. Earlier Indian Penal Code, there were some definitions. I don't remember exactly. Death. The definition is death of a person. You got the point? Death of a person. There is a definition which does not define. You got the point? BNSS 23 explanation 5 also same thing. They don't give guidance which required to be incorporated. That is what is. Now, enhanced punishment for certain offences after previous conviction. This is a very, very important principle which Honorable Supreme Court also time and again mentioned. I think the essence is as follows. Whoever having been convicted by a court in India of an offence punishable under chapters, etc., with imprisonment of the description to 3 years or upwards, shall be guilty of any offence punishable under either of those chapters with life imprisonment for the like imprisonment and for the like term, shall be subject to every such subsequent offence to imprisonment for life or imprisonment of either description for a term which may extend to 10 years. Please remember, this is aimed at habitual offenders or repeat offenders, where the next conviction will be much more deterrent, which is statutorily a kind of guidance is given, which requires to be followed. If we look into all these punishments, particularly I have selected some of the punishments, primarily to indicate punishments where judicial discretion is inbuilt, minimum sentences, minimum mandatory sentences, death sentence. Life imprisonment also, please remember, for certain offences, there is no judicial discretion. Death or life, for example, 303 earlier. Now, death sentence, life imprisonment, 103 punishment for murder, 104 punishment for by, just now I mentioned, 303 means 104. 107 abetment of suicide of child or person of unsound mind. This is a very new edition where the emphasis is on the victim being child or a person of unsound mind. Unsound mind, you know, the unsound mind phrase they no longer use in BNS. They use mental illness. But in this context they have used. 7 years imprisonment and above. Section 99, buying child for purposes of prostitution. 143, trafficking of person. 231, giving or fabricating false evidence with intent to procure conviction of offence, punishment with imprisonment for life or imprisonment. All these are 7 years imprisonment and above. 3 years imprisonment and above. Section 95, hiring, employee or engaging a child to commit an offence. 111, organized crime. 144, exploitation of a trafficked person. These are all select offences, please remember. The purpose is not to cover all the offences. No, just to give you an idea. 6 months imprisonment and above. 199, public servant disobeying direction under law. 204, personating a public servant. 314, dishonest misappropriation of property. Sentence with judicial discretion. 153, waging war. 150, concealing with intent to facilitate design to wage war. 151, assaulting president, governor, etc., etc. Minimum sentence with judicial discretion. Supreme Court held that the court cannot impose less than the minimum sentence. I hope all of you are aware. Supreme Court is very categorical, stating that legislative prerogative must be followed and you have no discretion to. Correct. Probation of Offenders Act cannot apply. Absolutely. Absolutely. Then comes minimum mandatory sentence, buying child, section 19, 1 for trafficking person, 95 hiring, employing, etc. On one hand, my observation with regard to the scheme of punishments under BNS in comparison to earlier Indian Penal Code, the duration of punishments increased. Duration. I am talking years of imprisonment, etc., increased. Yeah. Secondly, the constitutional repeal, in the sense when the constitutionally struck down a particular offence, it was reopened by incorporating a different punishment. That is section 104, murder by life convict. They have included the death sentence or life imprisonment. Third, minimum mandatory sentences, minimum sentences, I think number has increased in BNS. As a result, either trunking or shrinking the judicial discretion part or negating judicial discretion part. I think both ways it. Personally, I am of the opinion that unless in very exceptional cases of most serious offences, I think minimum sentences may be possible, but sentence with judicial discretion is the most preferred route. It is only because, on one hand, honorable judges, in the light of the evidence that gets adduced, they are in a better position to decide about the proportionality of the sentence. My dear friends, the proportionality of the sentence is the most important fine-tuning when it comes to the criminal justice. I mean, when Sir mentioned about some of the judges' conviction or acquittal, etc., I'll tell you this is very common. I mean, I'll tell you about my own profession, teachers. Some people, they select some subjects offered by some teachers. You know why? They get very good marks. I'll just complete. No problem. Some people, they select courses depending upon the subject, irrespective of the teacher. It all depends. I think it is in our human trait. I am not either holding brief or judgmental. No, but these things do happen. We need to have structural balances in terms of things, etc. Sometimes we may fail, sometimes we may succeed, but I think it is an ongoing process. Because even I asked one student, how come you got such a very good rank, very good mark, but you did not get that rank in my subject. Then he said, that is the reason why I took that subject. He said. And he is so honest. And he got it. And I am very happy. But I am saying these things, structural things happen. But having said, proportionality can only be possible, not by legislative prescription, but judicial exercise of discretion. That is something we need to believe in. And I believe in. Yes. 153.
The waging war against the government of any foreign state at a peace with the government of India, at peace with the government of India. If it is not a peace,
I mean, in the sense, friendly nation we call. I mean, very honestly, strictly speaking, unless a particular war or something, majority of the countries are with peace only. I mean, for example, Canada, peace only. No doubt serious accusations are taking place to and fro, etc. But I don't know whether the same thing can be said about China. You get the point. Same thing can be said about Pakistan. But otherwise, generally, the reason why they say is the friendly nature of the two nations is bilateral in nature. They will help us whenever I need, and I will help them whenever they need. It is something. Correct. Similar kind of thing, etc. Therefore, in other words, when we talk about this, I mentioned the particular punishment, etc. We have to. I think, in consonance with that objective, what has been stated in the Lok Sabha, punishment scheme has been. Yeah.
quantum of punishment, the full work of quantum of punishment is often aligned with the nature of imprisonment, period, and the amount of fine, which is left to the discretion of the judge.
Correct, correct. Absolutely. Yeah. In fact, okay, no, what you said is what is being practiced as a method to ensure proportionality. To tell you, Supreme Court judgments are very clear in terms of extenuating circumstances and mitigating circumstances. The focus is always on 5 aspects: the nature of the crime, the background of the criminal, the method and the manner in which operation done, modus operandi, 4th, the victim, and 5th, most important thing, what is the extent? All the factors will be taken into consideration. Having said, no doubt we got some guidance with regard to when and how death sentence is to be, that is a different matter. Sajjan Singh, etc., etc. But when it comes to the imprisonment related, these factors are considered. Fine. Well,
Imprisonment is provided more than 2 years or 3 years. Often it is coupled with the fine.
correct, correct. The reason, one thing is that Honorable Supreme Court time and again mentioned about certain factors. One is, whenever we talk about the background of the culprit, maybe in terms of his education, his service, those things may not be having a direct, but these things you may have to consider in order to either mitigating the sentence or whatever, as a matter of justifiability. Another thing, the violence manifested in terms of modus operandi is the key factor for enhancement of.
Because of the relationship of the victim and the accused, there is every chance of nurturing the intention to commit the offense.
Correct. In fact, I would say motive.
That is how the motive is.
Get because the intention is backed by the motive. As a result, the person executes that particular thing. And
Nurturing of the intention to commit.
yes, correct. And that is one important factor for you to take the sentence.
Often substantial evidence to appreciate the intention is not often available in all the cases of
Correct, correct,
It has to be ascertained from the manner of commission
correct,
alone
absolute,
and the consequences ensued from the
correct.
alleged offense.
In fact, that is the reason why, even in terms of the nature of the evidence, there may not be direct. It is only a chain of circumstances. But still, chain to chain, if there is a reasonable explanation which does not break the chain, that's correct. Absolutely. I think all these aspects, somewhere down the line, I feel BNS negating many things because of minimum sentence, minimum mandatory sentences. In a way, they constrain the space available for judicial discretion. I think that is something we need to. Yes, please. Hmm.
235.2 and 248.2.
Correct.
They speak about hearing on the aspect of
I
sentence.
know.
My learned friend said, what happens after that hearing in the matter of sentence, proportion, I mean, the punishment to be imposed, quantum of punishment. In the process of hearing, you will have to ask the accused who is before you, what is his background.
Correct.
Maybe there is no means of counter-checking, true. But the way in which he conducts himself, the way in which he presents himself, your judicial conscience and experience should tell you his background. Maybe he says, my income is only 5 rupees per day, cannot be accepted. Having regard to those aspects, what we generally say, her PP submits that maximum sentence may be imposed, accused counsel submits leniently in my view. But what is that view? It should be supported by reasons.
Correct.
For that, you will have to call the accused near him, ask him his background, educational background, social background, what is his present status, if he is in custody, what he was doing prior to he being taken as custody. There will be some input. Maybe in cases where death sentence and other things, a detailed hearing is called for.
Correct.
Because aggravating circumstances, mitigating circumstances. In our usual course, I think that exercise at the time of hearing, this is what is involved. He said, What happens after the hearing, how to adjust that till quantum and all that. In the process of hearing, this exercise needs to be done. Secondly, in the morning when I said about that summons trial, warrant trial, what I meant was, while recording evidence, we are not just following it.
Okay, okay.
That's
okay.
it. Now, the scheme of the whole provisions say that in a summons trial, there is no need to hear the accused before you pass a sentence. Don't hear, no problem. You are not compelled to hear. But you have to give reasons. Even if it is a summons case, 2 years is the punishment in respect of summons trial. You give 1 year, you fine him. You should give reasons.
Correct.
Hearing and sentence is one thing, there is no need, all right, because statute says it.
But where from you are going to get the
Correct.
reasons?
That's what I have been telling. A word from you also would,
Sure,
would corroborate my...
Sure, sure. In fact, I mean, you are so humble and nice, you have left out the so-called lawyers, whose duty, that you have not mentioned. No, you leave it, but I want to mention. Because prosecutors you mentioned, judicial officer mentioned. I am saying the lawyers have a more important duty to bring it to the notice of the court. If the person, if I am a defense lawyer, I mean, I can't give up the case because he is convicted. They disappear, yeah, absolutely. I am saying the responsibility I must shoulder, I must provide information to the court, etc. Now, the point is, when it comes to the summons trial of 2 years, where there is no 235 clause 2 type of duty on the part of the court to hear, etc., in my opinion, because you have to record reasons why, whatever the tenure of imprisonment or whatever, 6 months, 3 months, whatever, you need to record. How do you record reasons? You need to get the information. You know what is that? That is nothing but indirectly informing you, you hear the accused or the convict. Pose questions. 313. What do you do in 313? No. Yes. Yeah, but my point is, questions are there. No, I know that. No, I know that. I am only giving a parity. In terms of 313, you pose questions, no? Even with regard to writing reasons, you need to get information. Liar is gaib. And the person is there. He says only 5 rupees I earn a month. How do you? Therefore, talk to him. The reason why I am saying is, the best part of the role of a judge, according to me, is the judgment delivered. The standard, the credibility of a judgment always depends upon the reasons that are given in the judgment. My dear friends, judgment has a remarkable character in a democratic country. You know what is that? It has that communicating capacity. Whether it is from trial court or sessions court or high court, communicating. All our teachings, they based on only judgments. Because judgment is such an important thing. Therefore, it is necessary, as Somashekar Garu mentioned, that though there may not be a duty, but if you hear the accused, reasons, for that purpose you have to talk to him, etc. Correct. In fact, yeah, but normally what happens is, counsel is the person who is the bridge between the accused and the judge. No. That's in fact, the moment he hears, jump. That is it. But my point is, that's where if the counsel is not representing or not present, I think all the more reason why you need to speak to the accused, so that you are in a better position too. I mean, friends, misplaced sympathy for a criminal is not the answer. A criminal in terms of, but having said, what ought to be the punishment, it is in your hands. Because at least to that effect you have discretion, etc. I think that's it. Okay? Thank you. And I think 15 minutes, Amrita madam, 15 minutes before. Correct? Okay. Thank you. Friends, before Satish ji says, I want to. For any teacher, the real satisfaction comes when interaction is more. That is what is ensured and came out very well. And I am very happy. I am really happy. That is one thing I always hold you in esteem, because the kind of work you do and the society what it needs. Less of appreciation of what you do and more of criticism about what you don't do. Therefore, we need to understand. I think because all of us, we have a common cause, common purpose. I think that's where, thanking you for your attention and particularly post-lunch session, and I thoroughly enjoyed. Thank you.
Thank you very much, sir, for your outstanding presentation on the subject. Your expertise and insights on the subject captivated us and left a long-lasting impression on us. Both the sessions, as you said, were very interactive, and it has benefited all of us in enhancing our knowledge on the subject. I, on behalf of Karnataka Judicial Academy and participants present here, express gratitude and extend warm thanks. As a token of gratitude, we present a book to you, sir. I request our Honorable Additional Director, Sri Shantana Alva, sir, to present the book. Kindly accept the same, sir.
Hello, camera. Yeah. This is the documentary evidence. Yes, yes.
Thank you all. With this, we conclude for the day. IT is arranged. Kindly join us. Thank you, sir.